So, I'm sorry. My Lord, I have filed an affidavit with permission for application to file an additional affidavit in petition number 1037 of 2019. That's Mohammed Akbar Law versus Union of India. My Lord, this affidavit, something very startling has come to our knowledge, my Lord. The petitioner one, Mohammed Akbar Law, my Lord, he had said, my Lord, at so many forums and in the Legislative Assembly, Pakistan Zindabad. And my Lord, he still has no remorse about that. I have annexed along with my additional affidavit all his, my Lord.
We also read the newspapers because a lot of things which are said in affidavit are preempted by giving the news to the newspapers. So you've seen the newspapers. It's all right. Why, fair enough. We are now
lead petitioner in the lead petition saying Pakistan Zindabad on the floor of the House has its own seriousness.
All right.
The Lordships may look at it, my Lord, then who is contesting
fair enough.
claim of continuing 370?
We are going to hear you for 2 minutes, so you can make that point when you are called out.
Yes. In addition, I submitted my additional note, 3 pages note that will be taken in record on Saturday. I find.
I will take that. Anyway, you've made your point.
At least apologize.
We should file an affidavit that I owe allegiance to the Constitution of India because I am before the highest court of the country. And I object, my Lord, he must say that I strongly oppose terrorism and secessionism in Jammu and Kashmir. The learned AG is here.
Somebody record us. It's not the newspaper alone. It's and not only within on the floor of the House, he reiterates outside the. I stand by it. It's not that the newspaper barely carried it out and
we have media reports that he said exception is not complete. It's not complete at all. He has said so many other things.
Since he's invoking Constitution of India, then he can't stand outside the Constitution of India also.
All right, we got your point.
I'm grateful. Matter of propriety, I'm grateful.
There must be some reports that
not remorse, my Lord. He must say that I oppose and object to terrorism and any secessionist activity by Pakistan in Jammu and Kashmir or elsewhere. It must come on record.
He is a petitioner in which petition?
In the lead petition, my Lord. But for your Lordship's decision that it would be titled as Ray Article 70, he would have been the main petitioner.
1037 of 2019.
Shah Faisal, my Lord, after withdrawal, he is the next. And he is not an ordinary man, my Lord, he is a member of parliament.
And, when he made this
1037 of 2019, titled, my Lord, Mohammed Akbar Law and another versus Union of India. And others. I'm grateful. Okay.
Yes, Mr. Giri.
I have requested the Lordship that I'll give a note not mentioning the paragraphs of IR follow.
Yes.
I have circulated.
You have circulated that one. All right.
Also drawing attention to a speech of Sardar Patel where he says democracy is not in alliance with dynasty.
No.
Hey, please, Lord.
Just one submission, Lord. Somebody comes before the highest court of the land, to the Constitution bench of the Supreme Court, challenges, my Lord, presidential orders, prays for several other comprehensive reliefs, And my lord, he doesn't apologize to your lordship, sir. If he has made that statement, my lord, his submission should be taken into account. Only if he apologizes before he puts it on affidavit. There's one.
We'll put it to Mr.
Yes,
Counsel
yes.
when the rejoinder is called out.
Yes.
It's
Not as
for the court. Despite it being brought to the notice of the court, if he does nothing, it might encourage others. The efforts of the nation to bring in normalcy, which is substantially not successful, might be affected. And coming from responsible leaders, it has its own context and it has its own seriousness.
Yes, Mr.
Yes. No, my lords, the one aspect on federalism, my lord, which has, I believe, my lord, trying to present a facet before your lordships, which obviously your lordships would have been taken through earlier, but just one aspect of it, my lord, in the context of abrogation of 370. My lord, if your lordships could kindly come to some portions, my lord, of the opening remarks of Dr. Ambedkar, volume 8. Both the opening remarks and the closing remarks, my lord, are at volume 8 of the convenience compilation of documents. PDF page 5. By the way, my lord, the opening remarks presenting the draft constitution was made by Dr. Ambedkar on 4/11/1948. And my lord, the closing remarks came after the draft constitution was drafted on 25/11/1949. But if your lordships kindly come to PDF page 5, my lord, the paragraphs which begin, just a short paragraph in between. So far, I have explained the form of government under the draft constitution. I will now turn to the other question, namely the form of the constitution.
Very famous speech, very famous extract from Dr. Ambedkar's, yes.
Lord, sir, one reads it again and again, Lord, and one is astounded by the vision of this great man. Two principal forms of the constitution are known to history. One is called unitary and the other federal. The two essential characteristics of a unitary constitution are the supremacy of the central polity and the absence of subsidiary sovereign polities. Contrariwise, a federal constitution is marked by the existence of a central polity and subsidiary polities side by side, and by each being sovereign in the field assigned to it. In other words, federation means the establishment of a dual polity. The draft constitution is a federal constitution as much as it established what may be called a dual polity. This dual polity under the proposed constitution will consist of the union at the center and the states of the periphery, each endowed with sovereign powers to be exercised in the field assigned to them, respectively by the constitution. The dual polity resembles the American constitution. The American polity is also a dual polity. One of it is known as the federal government, and the other states which correspond respectively to the union government and the states government of the draft constitution. Under the American constitution, the federal government is not a mere league of the states, nor are the states administrative units or agencies of the federal government. In the same way, the Indian constitution proposed in the draft constitution not a league of states, nor are the states administrative units or agencies of the union government. Here, however, the similarities between the Indian and the American constitution and the differences that distinguish them are more fundamental and glaring than the similarities between the two. The points of difference between the American Federation and the Indian Federation are mainly two. In the USA, this dual polity is followed by a dual citizenship. In the USA, there is a citizenship of the USA, but there is also a citizenship of the state. No doubt the rigors of this double citizenship are much assuaged by the 14th Amendment to the Constitution of the United States, which prohibits the states from taking away the rights, privileges, and immunities of the citizen of the United States. At the same time, as pointed out by Mr. William Anderson, in certain political matters, including the right to vote and to hold public office, states may and do discriminate in favor of their own citizens. This favoritism goes even farther in many cases. Thus, to obtain employment in the service of a state or local government, one is in most places required to be a local resident or citizen. Similarly, in the licensing of the persons for the practice of such public professions as law and medicine, residence or citizenship in the state is frequently required. And in business where public regulation must necessarily be strict, as in the sale of liquor and of stocks and bonds, similar requirements have been upheld. Each state has also certain rights in its own domain that it holds for the special advantage of its own citizens. Thus, wild game and fish in a sense belong to the state. It is customary for the states to charge higher hunting and fishing license to non-residents than its own citizens. The states also charge non-residents higher tuition in state
You
colleges.
can skip that.
I'll skip that.
And you
The
can come to
proposed
page
Indian
8,
constitution.
Page 8, internal page, PDF page 7.
Yes, Miller.
The proposed Indian constitution
Is a dual polity with a single citizenship. There is only one citizenship for the whole of India.
Then another very important thing which Dr. Ambedkar makes a pointed reference to, if you look at page 8 top, the position in the US,
Yes.
each state in America is free to make its own constitution.
Correct.
And therefore the power of altering.
That's right.
And then what, Dr. Ambedkar says, Babasaheb says thereafter at page 8,
Yes.
is this is not true of
the proposed Indian
Just read that para, I think that
Yes.
will conclude it.
This is not true of the proposed Indian constitution. No states, at any rate those in Part 1, Model Part 1 as it was originally envisaged, because under the Indian Independence Act, my lord, under Section 6. But then that underwent a change, my lord, when it came to the final remarks, have a right to frame its own constitution. The constitution of the union and of the states is a single frame from which neither can get out and within which they must work. So far, I have drawn attention to the difference between the American Federation and the proposed Indian Federation. But there are some other special features of the proposed Indian Federation which mark it off not only from the American Federation, but from all other federations. All federal systems, including the American, are placed in a tight mold of federalism. No matter what the circumstances, it cannot change its form and shape. It can never be unitary. On the other hand, the draft constitution can be both unitary as well as federal according to the requirements of time and circumstances. In normal times, it is framed to work as a federal system, but in times of war, it is so designed as to make it work as though it was a unitary system. Once the president issues a proclamation which he is authorized to do under the provisions of Article 275, my lord, it must have become 356 later, the whole scene can become transformed and the state becomes a unitary state. The union under the proclamation can claim, if it wants, the power to legislate upon any subject, even though it may be in the state list, the power to give directions to the states as to how they should exercise their executive authority in matters which are within their charge, the power to vest authority for any purpose in any officer, and the power to suspend the financial provisions of the Constitution. Such a power of converting itself into a unitary state, no federation possesses. This is one point of difference between the federation proposed in the draft Constitution and all other federations we know of. This is not the only difference between the proposed Indian Federation and other federations. Federalism is described as a weak, if not effete, form of government. There are two weaknesses from which federation is alleged to suffer. One is rigidity and the other is legalism. That these faults are inherent in federalism, there can be no dispute. A federal constitution cannot but be a written constitution, and a written constitution must necessarily be a rigid constitution. A federal constitution means division of the sovereignty by no less a sanction than that of the law of the constitution between the federal government and the states, with two necessary consequences. One, that any invasion by the federal government in the field assigned to the states and vice versa is a breach of the constitution, and such breach is justiciable matter to be determined by the judiciary alone. This being the nature of federalism, a federal constitution have been found in a pronounced form in the Constitution of the United States of America. Countries which have adopted federalism at a later date have attempted to reduce the disadvantages following from the rigidity and legalism which are inherent there. The example of Australia may well be referred to in this matter. The Australian Constitution has adopted the following means to make its federation less rigid. Then, my lords, in coming to, my lords, the last paragraph beginning there, in assuaging the rigor of rigidity and legalism, the draft constitution follows the Australian plan on a far more extensive scale than has been done in Australia. Like the Australian constitution, it has a long list of subjects for concurrent powers of legislation. Under the Australian constitution, concurrent subjects are 39. Under the draft constitution, they are 37. Following the Australian constitution, there are as many as 6 articles in the draft constitution where the provisions are of a temporary duration and which could be replaced by Parliament at any time by provisions suitable for the constitution. The biggest advance made by the draft constitution over the Australian constitution is in the matter of exclusive powers of legislation vested in Parliament. While the exclusive authority of the Australian Parliament to legislate extends only to about 3 matters, the authority of the Indian Parliament as proposed in the draft constitution will extend to 91. It has then come to 97, 97 being an omnibus residuary clause. In this way, the draft constitution has secured the greatest possible elasticity in its federalism, which is supposed to be rigid by nature. It is not enough to say that the draft constitution follows the Australian constitution or follows it on a more extensive scale. What is to be noted is that it has added new ways of overcoming the rigidity and legalism inherent in federalism, which are special to it and which are not to be found elsewhere. First is the power given to Parliament to legislate on exclusively provincial,
Go ahead.
in normal times. I refer to Articles 226, 227 and 229. Under Article 226, Parliament can legislate when a subject becomes a matter of national concern as distinguished from purely provincial concern, though the subject is in the state list, provided a solution is passed by the upper chamber, resolution must be, my lord. Upper chamber by 2/3 majority in favor of such exercise of the power by the centre. Article 227 gives a similar power to Parliament in a national emergency. Under Article 229, Parliament can exercise the same power if provinces consent to such exercise. Though the last provision also exists in the Australian Constitution, the first two are a special feature of the draft Constitution. The second means adopted to, my lord, my lord, please come to the next page, my lord, PDF 12.
Yes.
Not that the others are not important, my lord, but then to save time, because anyway, your lordships would be going through it. One can therefore safely say that the Indian Federation will not suffer from the faults of rigidity or legalism. Its distinguishing feature is that it is a flexible federation. There is another special feature of the proposed Indian Federation which distinguishes it from other federations. A federation being a dual polity based on divided authority with separate legislative, executive and judicial powers for each of the two polities is bound to produce diversity in laws, in administration and in judicial protection. Up to a certain point, this diversity does not matter.
Just skip that a little bit now and then go to the bottom of that page.
Yes.
The draft constitution has sought to forge means and methods whereby India will have federation.
And at the same time, we'll have uniformity in all basic matters which are essential to maintain the unity of the country.
And then on the next page, Dr. Ambedkar refers to three things: a single judiciary,
uniformity in fundamental laws, civil and criminal,
and all India civil service. That we can then.
Yeah. No, my lord, the rest of it, my lord, but of course, your lordships would be, with the utmost respect, my lord, I would commend that your lordships have a look at
we have seen the key of
yes,
the key factors, the key features
correct
of the constitution which make it federal. At the same time,
yes,
preserve the need for
that's right,
a certain degree of uniformity.
That's right,
at the national level.
That's right, my lord. No, my lord, immediately, if your lordships cut the chase to the closing remarks, that's the famous, my lord, speech by Dr. Ambedkar.
1949.
Yes.
Where is that?
That is, my lord, at PDF page 1299, same volume. Yes. So I want
to read that.
Would you like to read it? Sir? No, sir, you can. You can lay emphasis on. Lord, PDF page 1299. 1299. Starts at 1299. The relevant portion is at 1307.
4160.
My lord?
4160 in red.
Yes, 4160. My lord, see, the relevant portion is again 1307. Continuous page is 4168. Can I read it?
Yes.
There's only one point of constitutional import to which I propose to make a reference. A serious complaint is made on the ground that there is too much of centralization and that the states have been reduced to municipalities. It is clear that this view is not only an exaggeration, but is also founded on a misunderstanding of what exactly the Constitution contrives to do. As to the relation between the center and the states, it is necessary to bear in mind the fundamental principle on which it rests. The basic principles of federalism is that the legislative and executive authority is partitioned between the center and the states, not by any law to be made by the center, but by the Constitution itself. This is what Constitution does. The states under our Constitution are in no way dependent upon the center for the legislative or executive authority. The center and the states are co-equal in this matter. It is difficult to see how such a constitution can be called as centralism. It may be that the constitution assigns to the center too large field for the operation of its legislative and executive authority than is to be found in any other federal constitution. It may be true that the residuary powers are given to the center and not to the states. But these features do not form the essence of federalism. The chief mark of federalism, as I said, lies in the partition of the legislative and executive authority between the center and the units by the constitution. This is a principle embodied in our constitution. There can be no mistake about it. It is ever wrong to say that the states have been placed under the center. Center cannot by its own will alter the boundary of the partition, nor can the judiciary, for as has been well said, courts may modify, they cannot replace, they can revise earlier interpretations as new arguments, new points of view are presented, they can shift the dividing line in marginal cases, but there are barriers they cannot pass, definite assignments of power they cannot reallocate, they can give a broadening construction of existing powers, but they cannot assign to one authority powers explicitly granted to another. The first charge of centralization defeating federalism must therefore fail. The second charge is that the center has been given the power to override the state. Then my Lord Dr. Ambedkar says, this charge must be admitted. But before condemning the constitution for containing such overriding powers, certain considerations must be borne in mind. The first is that these overriding powers do not form the normal feature of the constitution. Their use and operation are expressly confined to emergencies only. The second consideration is, could we avoid giving overriding powers to the center when an emergency has arisen? Those who do not admit the justification for such overriding powers to the center, even in an emergency, do not seem to have a clear idea of the problem which lies at the root of the matter. The problem is so clearly set out by a writer in that well-known magazine, The Round Table, in its issue of December 1935, that I offer no apology for quoting the following extract from it. Says the writer, political systems are a complex of rights and duties, resting ultimately on the question to whom and to what authority does a citizen owe allegiance. In normal affairs, the question is not present, for the law works smoothly, and a man goes about his business obeying one authority in this set of matters and another authority in that. But in a moment of crisis, a conflict of claims may arise, and it is then apparent that ultimate allegiance cannot be divided. The issue of allegiance cannot be determined in the last resort by a juristic interpretation of statutes. The law must conform to the facts, or so much the worse for the law. When all formalism is stripped away, the bare question is what authority commands the residual loyalty of the citizen? Is it the center of the constitutional state? The solution of this problem depends upon one's answer to this question, which is a crux of the problem. There can be no doubt that in the opinion of the vast majority of the people, the residual loyalty of the citizen in an emergency must be to the center and not to the constituent states, for it is only the center which can work for a common end and for the general interest of the country as a whole. Herein lies the justification for giving to all center certain overriding powers to be used in an emergency. And after all, what is the obligation imposed upon the constituent states with these emergency powers? No more than this, that in an emergency, they should take into consideration alongside their local interests, the opinions and interests of the nation as a whole. Only those who have not understood the problem can complain against it. My Lord, there is an anguish. Sorry. Let's see. Just one paragraph in the next two lines in the next paragraph, my Lord. How the in what was the anxiety, my Lord, which he shared, and how prophetic, my Lord. Sometimes one feels that So prophetic he could have been. Here I could have ended, but my mind is so full of the future of our country that I feel I ought to take this occasion to give expression to some of my reflections thereon. And 26 January 1950, India will be an independent country. What would happen to her independence? Will she maintain her independence or will she lose it again? This is the first thought that comes to my mind. It is not, sorry.
Yeah, this is Aparajita sent me that. She's
This context.
For this also.
20.
Not that, my lord. These lines which start, the point is, today's context, my lord, the anxiety and the anguish, my lord.
You must complete reading that, Mr. Giri. It's a very interesting passage.
Yes, yes. This is the first thought that comes to my mind. It is not that India was never an independent country. The point is that once she lost the independence she had, will she lose it a second time? It is this thought which makes me most anxious for the future. What perturbs me greatly is the fact that not only India has once before lost her independence, but she lost it by the infidelity and treachery of some of her people. In the invasion of Sindh by Muhammad bin Qasim, the military commanders of Kandahar accepted bribes from the agents of Muhammad bin Qasim and refused to fight on the side of the king. It was Jayachand who invited Muhammad Ghori to invade India and fight against Prithviraj and promised him the help of himself and the Solanki kings. Then, my lords, I'll leave the rest. Next one, will history repeat itself? It is this thought which fills me with anxiety. This anxiety is deepened by the realization of the fact that in addition to our old enemies, in the form of castes and creeds, we are going to have many political parties with diverse and opposing political creeds. Will India place a country above the creed or will they place creed above the country? I do not know. But this much is certain that if the parties place creed above country, our independence will be put in jeopardy a second time and probably we lost forever. This eventuality we must all resolutely guard against. We must be determined to defend our independence with the last drop of our blood. No, my lords, these two my lord, speeches made by Dr. Babasaheb Ambedkar, two different points of time, one while presenting the draft constitution, the other after the draft constitution concluding remarks. There's not much variance, my lord, except to say that the slanting, my lord, if any, in the distribution of power, lawmaking power, my lord, towards the center was justified by Dr. Ambedkar after the constitution was drafted. No, my lord, it is after taking into all this that your lordships have also, my lord, over the years, after 1950, interpreted the constitution, interpreted the federal structure of the constitution. My lord, it has been done in many cases, but for the present, my lord, can I just give the paragraph numbers, my lord, and the PDF page numbers of some of the judgments, my lord, starting with State of Rajasthan versus Union of India. Just give the citation.
Just give us the page,
Yes.
the PDF
My lord,
volume.
volume 26. Volume 26. My lord, 1977 3 ACC 592.
That's okay. We have just give us the PDF volume now.
Yes.
The PDF
My lord, that
page.
is PDF page 54.
At
54.
para?
At paragraph, my lord, just.
So you're giving the PDF page of the relevant paragraph of the beginning of the case, whichever way you want to do it. Just give us the page at which the case begins and the
Yes.
page at which you are stressing the
Yes.
extract.
Yes. PDF 21. PDF 54, my lord, is a relevant paragraph.
All
Three
right.
paragraphs, my lord, from Chief Justice Beck's opinion.
All right. The next.
The next is, my lord, Bommai. Bommai, my lord, is in volume 2, page 2 onwards.
Page and at page.
My lord, that's what. My lord, there are multiple opinions in Bommai, as your lordship would have.
Right. But which are the paragraphs you
My lord, the paragraphs, my lord, can I start with, my lord, in the order in which it is given, my lord,
Sure, no problem.
Justice Pandian's opinion doesn't deal with federalism separately. PDF paragraphs 1 to 9. Therefore, PDF page 2 to 6. Yes. Sorry, PDF page 65, my lord, sorry. PDF page 65, the rest is all, my lord, editorial notes. Paragraphs 1 to 9, and in para 2, he agrees with the conclusions of 1, 2, 4 to 8 of Justice Sawant's opinion, my lord.
All right, then.
Kindly note that, my lord.
Yes.
My lord, see, PDF 68, Justice Ahmadi's opinion, para 10 onwards.
Just Ahmadi.
And the relevant portion, my lord, with regard to the federal character of the Constitution is at PDF 69, paragraph 13.
PDF.
69, paragraph 13.
Next.
Para 23 and 24 at PDF 75.
All right, next.
My lord, but para 247 and 248 PDF 206. My lord, the paragraph, my lord, Ramaswamy, Justice Ramaswamy's opinion, para 247 and 248 at PDF 206.
All right, so we've covered both.
My lord, there is a conspectus of the earlier decisions, including Rajasthan and Bomai, in NCT 2,
Yes.
volume 14, PDF 3, paragraph 68 to paragraph 77.
Page.
Paragraph 68 to paragraph 77. Just get the PDF page. PDF page. NCT. My lord, I'll give the page number in a moment. Volume 14.
Volume?
14. My lord, it doesn't have an SEC citation so far. SEC online is there.
Para 68 to?
Para 68 to para 77.
We'll have an SCR citation. I think all of you must now get into the
I
habit
think
of again citing SCRs. SCR is now digital. We have already got an eSCR. Hopefully in the next few weeks, we'll have a digital SCR. A digital SCR is exactly as it appears in the volume, while the eSCR, of course, is an electronic copy. And we have updated the head notes right up to probably the last month or so now. I'm not sure exact date, but we are pretty much now abreast. So we have a regular authorized reporting of reporter of the Supreme Court. Because SCR had fallen way behind its times, but now it's up to date, and it also has neutral citations as well.
Oh, that's right, my lord, it has neutral citations.
But we are now moving from an eSCR into a digital SCR. So the digital SCR will have a volume.
It always had neutral citations, Mulaz. It always had. And we were, in fact, used to only citing the SCR. But then, of course, it was not updated for many.
So I would really encourage all of you to just at least skim through the eSCR and
We'll do that.
And if there are any further improvements to be made, please feel free to let me know, because it's a.
ESCR in the first 20 years were head notes.
That's right. That's
They
what
were
I said.
outstanding.
Absolutely.
And that is what is missing. They gave complete picture of the case and what your lordship did.
Now, please have a look at the recent head notes. If there is some improvement, I'll be happy to do it.
My lord, and the corresponding ILRs in the high courts also.
We have revamped our editorial team for the SCR. We have a much broader editorial team. We also have a Center for Research and Planning in the Supreme Court, which is manned by several very talented young people who have been brought in from outside.
Seems that 24 hours are not enough for you.
They're not, Mr. Subbala. When I leave for home, there's so much to be done every evening
I
after
know.
that as well.
Appreciate it.
Some outstanding members of our bar with them, perhaps would
Of course, with pleasure.
likes of Mr. Shankar Narayan cannot, I have no doubt.
But please do have a look at our ESCR, and very shortly we'll have the digital SCR. So if there's any change, any improvement, let me know so that we'll do it.
Well, not strictly on this, but then I'll have to anyway. I thought of referring it in another context on which, my lord, I'll do it in a minute or so.
Also,
But,
the best
my lord,
part, it's a free service. So you can imagine lawyers
Yes.
across the country, from the
Yes.
districts
Yes,
to the high courts, have this
yes,
free availability of
Yeah.
resource material. Law colleges which can't afford to purchase software,
Correct.
they have this free service. It's searchable, absolutely. Yes.
my lord, earlier days I was a reporter for the ILR, my lord, in the High Court. And one good thing was, my lord, it kept one abreast with all the judgments, my lord, which used. But the numbers were not, it was not so numerous then. But in writing the head note always, my lord, was a task. Giving the head note was always a task, my lord. And one had to send it back to the learned judge, my lord, to get his approval also. Because otherwise, my lord, sometimes one misses out the crux of the judgment. And then, my lord, one, my lord, I'll just hand it over, kindly permit me. My lord, when Bomai came out, my lord, Bomai was delivered, Mr. Sorabji, my lord, wrote an article which was published in the SEC. My lord, just give 5 copies. My lord, I am not taking your lordships, but when your lordships have the time, just
Just keep that and put it in the.
Yes. My lord,
Well,
Mr.
just give us
Sorabji
what is the-
argues.
just give us a citation. You don't have
Yes.
to add papers now anymore.
94.3 SEC Journal 1. Just give copies.
1994.
1994 3 SEC Journal 1.
What was Mr. Sorabji's?
My lord, it's relevant, my lord, how Mr. Sorabji argues and persuasively how Justice Sawant's opinion, my lord, should be treated as a majority opinion in Bomai, not on the aspect of federalism. And then my lord says, my lord, this I'll immediately say why it is relevant, my lord, is because it is in Justice Sawant's opinion, my lord, that paragraph 153 comes as a conclusion. And 153.4, my lord, especially, that decisions could be taken, my lord, even irreversible decisions, there is a restriction on irreversible decisions. During the currency of a president's proclamation, till such time as a proclamation, my lord, is approved by both houses of the parliament. That's in para 153.4. I think the learned solicitor has brought your lordship's opinion.
Yes, we saw
Notice.
that.
Since the provisions contained, my lord, that is at page 149 of the report. Since the provisions contained in clause 3 of article 356 are intended to be a check on the powers of the president under clause 1 thereof, it will not be permissible for the president to exercise powers under subclause A, B, and C of the latter clause to take irreversible actions till at least both the houses of the parliament have approved of the proclamation. Now, this should be treated, my lord, in my respectful submission, as the opinion of the bench, as a majority opinion of the bench. Lord, I commend this with great respect. I commend this article of Mr. Sorabji for that purpose, my lord. When your lordships, it's in the beginning itself, my lord. It's a page. Lord, on federalism, I'll just make this proposition, my lord, and leave it before your lordships. I've given, my lord, the relevant paragraphs in the judgments, my lord. I've placed Dr. Ambedkar's opening remarks and the closing remarks. But especially in the last judgment of NCT 2, where your lordships, my lord, had a conspectus of the earlier judgments, my lord, which dealt with federalism. There are 2 or 3 features, my lord, which your lordships have outlined. One is that federalism is a basic feature of the constitution. Now, my lords, when your lordships have said that, the federalism, my lord, that is revealed, my lord, from the reading of the constitution as a whole. My lord, please keep 370 for a moment aside. Is, my lord, where the distribution of the legislative powers with the parliament and the state legislatures and with a slanting, my lord, in favor of the state. The reasons have all been given, my lord. I need not repeat it, myself, because your lordships have articulated it so well, my lord, in the in the earlier judgments. Now, my lords, whatever it is, your lordships will find that 370 constituted when your lordships have a holistic picture of the constitution and the relationship between the union and all the other states. And then if your lordships looked at 370, my lord, put in an area or carved out an area, my lord, which is not in sync with the general federal features of the constitution for the rest of the country, for the union and the rest of the country. Dr. Dhawan, my lord, pointed out other features, my lord, in part 21, 71 onwards. Point is, my lord, over a period of about 25 years, different provisions were introduced, were inserted in the constitution, giving a certain special provisions, my lord, for some of the states, and all, therefore, an amendment of the constitution and the parliamentary legislation. But point is, my lord, there are 2 or 3 features which emanate out of 370. One is that Parliament requires the consent of the state, the government of the state in relation to matters which are included in list 1 and 3, but not relatable to the instrument of accession. That the consent of the state is required for making applicable certain all provisions of the constitution which have been mentioned in clause D.
Just one second. As a consent of the government of the state on list 1 and 3 matters.
Yes.
Which matters do not relate to the IOA. That's right. Yes.
No, my lord, sin.
That is B2.
Yes, B2. D deals with such of the other provisions of the constitution shall apply in relation to that state, subject to such exceptions and modifications as the president may by order specify. And then the second proviso, concurrence of the government is necessary. That it has been done repeatedly, my lord, from 1950 onwards is a historical fact. But the point is, my lord, this sets out the relationship between Union and Jammu and Kashmir at a plane. I'm not saying higher or lower, I'm saying at a plane different from the constantly interworking relationship between the Union and all other states in the country, all other states forming part of the Union. Lord, when 370 is abrogated, you have a situation, my lord, which is, my lord, please consider the bifurcation of the state into 2 union territories, my lord, differently. That came about on 31/10/2019. I'm saying, my lord, said when 370 was abrogated by 272, and, my lord, all the provisions of the constitution became instanto, eo instanti, applicable to the state of Jammu and Kashmir. Jammu and Kashmir, therefore, became a state, my lord, on a complete par with all other states, my lord, in the union insofar as the federal structure is concerned. Even otherwise. My lord, what do the petitioners want? As a solicitor, my lord, was at pains to point out there is a great deal of expansion of rights, my lord, which could be enforced by the persons who reside in the state. But, my lord, what do the petitioners want? They want the 272 and 273 to be set aside and Article 370 to be resurrected. If 370 is resurrected, we would come back to a stage where there is an oddity insofar as the federal structure of the constitution is concerned. J and K would continue to be placed or would once again be placed on a plane different from all the other states of the union, and the federal working relationship which the constitution behoves us to do will meet with a roadblock one way or the other. Lord, I'm not saying that the one principle of administrative law which your lordships have always applied is, your lordships would not issue a prerogative writ in setting aside any order or setting aside any action taken by the executive. Lord, if such interference by your lordships resurrects, my lord, a situation that was also not completely legal. Lord, paraphrase it. If setting aside 272 and 273 resurrects Article 370, in my respectful submission, if Article 370 is resurrected, that would also be violative of the basic structure of the Constitution. Yes.
This might be a little too far-fetched because then that would be to postulate that original Article 370 was violative of the
There was a challenge. There was a challenge pending here for several years. 1986, when a batch of writ petitions was then made over to the High Court, whether that's still pending. There are people, my lord, who wanted to prosecute it. But of course, my lord, one of the writ petitions challenging 35A is also, my lord,
It was a part of the original constitution, Mr.
I'm saying, my lord, that the federal structure, my lord, I would only, my lord, let me go by the path of least resistance.
Can't invite us to hold in your favor on an unstateable proposition.
No, I'm saying, my lord, that your lordship, let me take the path of least resistance. My lord, the federal structure which emanates, my lord, from 370 is on a different plane from the federal structure.
Mr. Giri, you are not today confronted with a situation where Article 370 is in the Constitution.
I'm saying, my lord, that if there is a resurrection, then, my lord, there is still, my lord, a cause of action.
35A, etc. is on a different.
I understand, my lord. I'm saying, my lord, these.
I think we better wrap up.
I am wrapping up.
11:25.
My lord, just one aspect on which your lordships wanted an answer, my lord. In Madhav Rao Sindhya, my lord, 1971, 1 SEC 85. Volume 6, PDF 390. My lord, I'll just give the page number, relevant PDF page numbers and paragraphs. My lord, Chief Justice Hidayatullah's opinion, para 65, PDF 443.
What
Para
volume?
76, PDF 447.
Volume?
My lord, volume 6, my lord, of the case law compilation.
Yes.
Decision starts at PDF page 390.
So what is the proposition you're citing it?
My lord, it's only this, my lord. Your lordship, the solicitor had taken your lordship extensively through Ganpat Rao.
Yes, yes.
Which came about later. My lord, the mandamus was issued in Madhav Rao Sindhya, my lord, where after a serious bit of ratiocination, the lordships came to the conclusion, both Chief Justice Hidayatullah and Justice Shah, that the right which is claimed by the petitioners emanates from Article 291, Constitution, and 362, and not from the covenant. And this is same conclusion was arrived at to hold that 363, which is a bar on the courts, my lord, entertaining such disputes, is not attractive because the right claimed by the petitioners is on a right which is generated and frameworked in the Constitution and not in a covenant. That is why a mandamus is issued. We don't have a parallel
One
here.
second. You said that the rights, but Justice Hidayatullah and Justice Shah said that the rights which were claimed by the petitioners originated in Articles 291 and
362
and not in the covenant.
Not from the covenant.
And what is the next? What is the sequitur that?
And therefore, my lords, that 363 was not attractive. 363 has been subsequently repealed, but 363 was not attractive, and therefore a mandamus was issued. Therefore, my lord, the right claimed by the petitioners was under the Constitution itself. 291 and 362 were repealed. Earlier, my lord, it was only a question of, my lord, withdrawing the recognition of a ruler under 366(22). That was found to be inadequate because 291 and 362 were still intact. That is why, my lord, in the first matter, in Madhavrao Sindhya's matter, a mandamus was issued. When 291 and 362 were repealed by a constitutional amendment, my lord, no further right survived. There was no privy purse, my lord, which the right to a privy purse which emanated from the constitution or embedded in the constitution. The right was taken away by a constitutional amendment. That's why, my lord, in Ganpat Rao, a challenge to the constitutional amendment on the ground that it violated the basic structure of the constitution was repelled. My lord, petitioners cannot draw any sustenance, my lord, from the ratio of Madhavrao Sindhya is my respectful submission.
Thank you, Mr.
I am deeply obliged to you.
Thank you, Mr. Giri.
Yes.
You appearing for?
For a union.
But for the union, how many people will appear, Mr. Nataraj? We don't want to stop you because it's an important matter, but
I'll not
Take way.
repeat anything. And
can you formulate what?
Yes, I'll formulate. I'm cautious of the arguments already advanced on behalf of Union of India, and equally conscious of the time factor which is daring at me through your eyes.
Find you to 10 minutes.
Just I'll only on a different approach which I'd like to give to the entire the facets of this one with regard to the matter. Basically, I formulated 4 issues, which I will cover up within 10 or 15 minutes. I will not go beyond that. Article 370 is the only provision in the Constitution which has a self-destruction mechanism. There are other articles which would lapse by a flux of time. That is a different scenario altogether. Number 2, this article did not confer any kind of right. Number 3, continued application of
One.
Please, I'm sorry.
Continued application
Of Article 370 discriminated and opposed to basic structure. Fourthly, doctrine of federalism, the foundation which they have laid.
Just do it.
Please. In the stricto sense has no application insofar as Article 370 process is concerned.
What is the 4th one?
The doctrine of federalism, that federal structure principle, has no application in stricto sense insofar as process under Article 370 is concerned. Now, first let me deal with the last point with regard to the federal structure theory which they advanced or propounded in support of their contention. By virtue of it, the Article 370 abrogation and all this process, the federal structure has been violated. While dealing with that, first let me take this Honorable Court to the provisions under the Constitution where under the constitutional provisions can be amended. That is Article 368. Now kindly take Article 368 in juxtaposition with Article 370. There are 2 situations. Under Article 368, that is the provision under which the Constitution can be amended. that is the provision, which recognizes number one, constituent power. Number two, while amending the constitutional provisions, in most of the cases, we require the majority or the 2/3 of the majority as provided under Article 368(1). The second part is equally important, which recognizes federalism, is the next part, where the ratification. Article 368(2) that recognizes federalism in the matter of amendment to the Constitution.
Yes.
Kindly see the keywords under Article 368. Kindly take the keywords under Article 368. (368)(1), notwithstanding anything contained in this Constitution, President may, in exercise of its constituent power, the constituent power is explicitly brought into the constitutional provision for the purpose of amendment under Article 368(1), in exercise of constituent power, amend by way of addition, variation, or repeal any provision of this Constitution in accordance with the procedure laid down in this article. So, for the purpose of repeal, the power exercised is recognized as a constituent power under Article 368(1). Now, kindly go to 2. An amendment of this Constitution may be initiated only by the introduction of a bill for the purpose of either house in a parliament, and when the bill is passed, each house by a majority of total membership of that house, and by a majority of not less than 2/3 of the members of the house are voting. That is the second part. Then proviso, provided that if such amendment seeks to make any change in Articles 54, 55, and so and so, the amendment shall also require to be ratified by the legislature of not less than 1/2 of the states. So the collective consent theory is introduced under Article 368 for the purpose of amendment of the Constitution. It is a collective consent which is required under Article 368 for the purpose of amending the Constitution. In a way, it is a veto power conferred upon the majority of the states. Now, have 370, Articles 370 in a juxtaposition. Kindly go to Article 373. Notwithstanding anything contained in these provisions of this article, the President may, by notification, declare that this article shall cease to be operative or shall be operative only with such exceptions or modifications as may specify, provided that the recommendation of the Constituent Assembly of the state so and so shall be necessary so and so. 368 speaks of the ratification, a collective consent, and the veto power as a recognition of federal structure is embodied under Article 368. However, when it comes to Article 370, the language is only recommendation, which already they pointed out, it is only
It's been argued consistently.
Please.
The word recommendation has been argued.
Therefore, I am not touching. I am pointing out the difference between the ratification as a matter of the federal structure, which is brought in for the purpose of amendment, and 370, which only says the recommendation. So,
but equally, the adaptation to the Constitution ensured that even in the matter of an amendment,
yes,
the President has to still go through the route of Article 370(1).
Absolutely. Therefore, in the stricto sense, Article 368 principles of getting it ratified will not be applicable to when it comes to 370, only the recommendation is required, which has a very, very limited.
When additional safeguard was introduced.
Correct.
And that safeguard is not merely in matters which require ratification by half the states.
Correct.
But any constitutional amendment has to go through the process of Article 370.
370.
In relation to J&K.
J&K.
As it then stood.
Yes, that's right. But however, reading these two articles in a different language will make either of them redundant. Otherwise, straight away we can go under Article 368 for any kind of amendment of the Constitution.
Whether amendment provisions will have impact on different states.
Correct.
It's the provision which only has an impact on
When the larger power under Article 368 itself is conferred for the purpose of certain amendments of the Constitution. When 368 itself is available, there is no question of applying 370. Reading in any other form makes 370 redundant. Or if you apply 370 in any other form, 368 makes redundant.
It's always been put to us that 373 was a self-destructive mechanism so far as 370 is concerned. That we've already noted.
Senator,
Please.
what you're probably trying to highlight
Please.
is that the argument that the federal structure gets affected because of abrogation of 370
Yes.
should not be accepted for the reason
Yes.
that the federal structure is protected by 368
Yes.
itself. And you cannot say that federal
Absolutely.
structure is diluted in case 370 is
370 is concerned. So federal structure is applied and protected under Article 368, and under Article 370, there is no such strict application of federal structure for the purpose of Article 370. Any other interpretation would in a way makes either 370 or 368 a redundant provision. No constitutional provision. So therefore, power conferred under Article 370 is a unique, superior power. It is neither a constitutional power, nor a legislative power, nor an executive power. However, it has the flavor of all three. It is a superior power conferred under the Constitution on the President to introduce.
Now look at our problem.
Yes.
Your two ASGs arguing two different things. Mr. Dwivedi said it's a constituent power.
It has the flavor. Yes, it
Of
has.
course, Mr. Dwivedi is not an ASG, but
it-
the point is he's on your side.
Yes.
Now, at some point, we were told that they had differing interpretations.
Yes.
Now we are in a situation where the respondents are coming with
It has the, yes, it has the flavor of all three. It has the flavor of all three.
What I don't understand is,
Yes.
attorney and solicitors are given a perspective of how the constitution is understood from the
Yes.
government perspective.
Yes.
Will we have different perspectives?
No, not at all, not at all, not at all. It is in line with the argument advanced by learned Solicitor General. What we say that it is a unique, extraordinary power conferred on the President to abrogate or to bring in certain changes in the Constitution, which has the flavor of constituent power, which has the flavor of executive power, which has the flavor of legislative power. So that is a plenary power conferred on the President. And when such a power is conferred on the President, plenary power, we need not or we should not treat with any kind of limitations for exercise of such power. Such an extraordinary power conferred on the President need not be or should not be read with any kind of limitations. And it must be given fullest meaning and to be applied without any procedural restrictions.
The proviso has to be forgotten.
Proviso has to be followed. There is no doubt about it. But you can't equate with the Article 368 that the stricter.
If the proviso has to be followed, then what happens to the requirement therein?
No, the requirement is correct, but the yardstick is totally different. We can't equate with the procedure required to be followed under Article 368. proviso need not be in the strict it need not be followed. And when it's a plenary power, it need not be read with the limitations as held in R versus Burra, which has been applied in the Keshavananda Bharati.
Thank you, Mr. Naidoo. Thank you very much, Mr. Naidoo. Mr. Jetnani.
Clarification. Whether the power is constitutional power, executive power, or administrative power. But that exercise is irrelevant. It is a sui generis power, given only in one article to the highest constitutional. That's not the.
Yes, Mr. Jetnani.
Now I appear for the interveners in 171690.
Could you repeat that, Mr. Jetnani?
But I number 171690 in in the lead petitions, in the lead petitions. I am the intervener. One of my clients.
In 1047.
Yes, in 1037.
1037.
Well, my clients basically are members of the Gujar Bakarwal community in Jammu and Kashmir. The members of a scheduled tribe. They constitute 73.25% of the total scheduled tribe population of Jammu and Kashmir.
73.25%.
73.25%. Of course, we strongly support the amendments for the reason that the provisions in the Constitution pertaining to scheduled tribes, 330, etc., were never applied.
But Mr. Jetnani, your knowledge is theoretical unless you can state with certainty before us that you have driven around in Ladakh. Have you been?
I've been to Ladakh. I have been to Ladakh. But Manoj, many years ago, many years ago, Manoj, in the days when houseboats used to flourish, in those days, and they've come back now.
Houseboats are not there in
Ladakh. I have not seen a houseboat in Ladakh.
No, houseboat in Srinagar and then from there on. Why don't you go there? I'm told a lot of people go there now. It's go there and take a look for yourself. Empirical evidence will stare you in the face. The Himalayan car rally, which used to take place then in the former days, has now been revived. But my daughter's scheduled to go soon to Leh and Ladakh in that Himalayan car rally. So they're taking a sports car themselves and traveling up. She and her friends.
Justice Variava used to participate.
Yes, your Lordship is right, Justice Variava. All affirmations from reaffirmations from the other side about the congenial climate that now takes place in Jammu and Kashmir. But my clients are restricting themselves to the challenge to 373 and the proviso thereto, as also to the amendment to 367 brought about by CO 272. I'm not going into the question of 356 and the territorial reorganization. That's beyond tribal folk. And 356 really deals with the satisfaction of the president and the governor's report and so on. Matters which are best dealt with by the government. So I'm not going into that. I'm going to these two questions only.
You're going to go into 373?
370, the proviso.
And?
And 367 amendment, which replaced by CO 272, dated 5th August 2019, which substituted the word Constituent Assembly with the word Legislative Assembly. Incidentally, I might just mention that my clients are the beneficiaries subsequent to 5th August 2019.
Actually, you very helpfully identified the 4 key areas in the case,
yes,
which the case turns. 1, 370 itself, and the proviso to 370 bracket 3. 2, the use of the amending power under 367. 3, the reorganization. And 4, 356.
Those are really the 4 issues which arise in this.
4 areas, I would say, for the issues which arise from.
So, with regard to the latter 2, I'm adopting the arguments of the state, of the government.
All right. How would you formulate yours so that then we
yes.
can...
I've submitted written submissions
Yes, we have got
2 days ago. Yes, sir. But briefly on the question of sovereignty, where does sovereignty lie? Because it then dovetails into the question, which are the subject matter of the 2 issues I'm going to deal with. Just a brief overview about the sovereignty question. And I divide it, sovereignty can be looked at in various different ways. There are many divisions, external, internal, political, legal. But I'm going to just talk about the political and legal sovereignty very briefly, these 2 issues. And as far as political sovereignty is concerned, there is no doubt that the other side has not even seriously challenged its political sovereignty rests with the Union. And the clearest indication of that is the preamble. Political sovereignty rests with the Union. Qua the state. And a simple look at the preamble, my lord, would indicate that. The preamble of the 2, the Union and the federating unit to the state of Jammu and Kashmir, would reveal that. A point noted by Justice Nariman in the State Bank of India case. I mean, we kindly have a look first at our preamble very quickly. We, the people of India, having solemnly resolved to constitute India into a sovereign, the word sovereign is key, socialist, secular, democratic republic. Now, in contrast, the Constitution of Jammu and Kashmir has the following preamble. We, the people of state of Jammu and Kashmir, having solemnly resolved in pursuance of accession of this state to India, which took place on 26th October 1947, to further define the existing relationship of the state with the Union of India as an integral part thereof. So now the preamble itself makes no mention of sovereignty. In fact, the preamble is dealt with further defining the existing relationship of the state with the Union as an integral part thereof. Come on, it's an acknowledgement of the Union's sovereignty over the state. This is political sovereignty. The Constitution was geared towards defining the relationship of Jammu and Kashmir for the Union as an integral part of the Union.
Yes.
And first and foremost, The permanent residents of the state of Jammu and Kashmir are citizens of India. Although Mr. Lord may sometimes behave that he's not, but in fact he is. And now I come to the question of legislation. Legislative sovereignty is divided between the union and the state. And on a look at Article 370, which is the governing article of the relationship between the union and the state. Matters in the concurrent and union list acceded to by the then Maharaja are within the realm of the center, the union. And broadly speaking, one of the other parts of the Constitution are within the jurisdiction of the state.
But therefore, the sequitur of your argument would be that matters which do not form part of the instrument of accession in relation to which the union was given exclusive control,
Yes.
the four matters,
Yes.
the legislative sovereignty would therefore continue to vest with the Jammu and
Continue to
Kashmir
vest,
Legislative Assembly.
subject to the power of the president to apply the provisions of the Constitution under B 1 and 2, but with the concurrence or the consultation of the state. So any provision, theoretically speaking, if those qualifications arise, if that concurrence or that consultation takes place, then the entire Constitution can be applied to the state of Jammu and Kashmir under 371. 373 is distinct from 371 because it's at a one-stroke abrogation of the entire Article 370.
Therefore, Mr. Jitnani, you therefore also necessarily accept that there is a concept, sovereignty has two connotations.
Yes.
One, external sovereignty,
Yes.
which undoubtedly vests completely with the Union of India. Internal sovereignty, which is then distributed between the Union and the states.
Yes. Yes. That's a patent look at that. Nobody can deny that. But the Constitution envisages that from time to time, further and further, and that's been the, as has been pointed out repeatedly during the course of these arguments, that with the passage of time from 1950 onwards, more and more provisions of the Constitution have been made applicable. And some of them are those which were not originally applicable to the legislative or within the legislative jurisdiction of the center. But ultimate legal sovereignty rests with the union. And though that is Article 373. Article 370, sub-article 3 is indicative of the fact that ultimate legal sovereignty, in the sense that you can get rid of the tunnel altogether that connects the union with the state legally and constitutionally. Ultimate legal sovereignty rests with the Union of India. And 373 is key, is one of the key issues in this entire discussion. It's in all these arguments, 373, and the reading of the proviso, the effect of the proviso. That establishes most of the issues that arise in this case, at least it sets a platform whereby the others can be. Absent that, there would be nothing else, which is why the other side is at pains to point out that after the Constituent Assembly dissolved or became extinct, 373 has no application. In other words, the substantive part of 373 is now swallowed by the proviso. The absence of the Constituent Assembly and the power of recommendation which was vested in it has now disappeared. That's their case. On that proviso, I'll have something to say. But this is the sovereignty issue. Now, there is also Article 147, which is some indication of legal sovereignty of the state of Jammu and Kashmir. That's the amending part. That is an acknowledgement. The third part of C, clause C of 147, is an acknowledgement by the state of Jammu and Kashmir that they cannot touch the Constitution of India as applicable to the state of Jammu and Kashmir. Now, the issue of Article 373 and the proviso thereto, it actually dovetails into three questions which I'll just frame, which are at the heart of the controversy here. The first is Article 370 temporary or permanent? With the extinction of the Constituent Assembly of Jammu and Kashmir, referred to in the proviso to that article, render entire Article 373 OSHOs. And third was the amendment by CO 272, dated 5th August 2019, to Section 377, to Section 367. Sorry, to Article 367. Article 367. By the addition of clause 4D, that article which made Constituent Assembly read as Legislative Assembly, was that constitutionally valid? But
Just since we have 55 minutes now to lunch, we'll give you time till 12:20. Mr. Guru, 12:35. Then we will hear the interveners for 2 to 5 minutes, and then we'll give Mr. Banerjee the interveners between 12:35 and 12:50, and Mr. Banerjee 12:50 to 1. That's the way we'll do it.
But because I have to read some extremely important constitutional orders, see, just very briefly.
Give us the page.
Yes, but I just want to
para.
read the portion that I'll tell your lordship what my argument. I'll come to it in a minute.
Well, let's get to the argument.
Yes,
We
yes.
are losing
Let's
with
not
the
waste
15 minutes
time,
available.
time management. I agree.
Yes.
My lord, as far as the temporary and permanent part is concerned, two issues have already been discussed. One is Article 370 is a provision that is a part of Chapter 21 of the Constitution of India, which deals with temporary provisions.
Yes.
Lordships have already noted that. Second is the title of the article, which describes its provisions as temporary provisions with respect to the state of Jammu and Kashmir. And my lord, third is the effect of the proviso requiring the prior necessary recommendation of the Constituent Assembly of Jammu and Kashmir before the president can act under 373(1).
Your contention is that the Constituent Assembly of Jammu and Kashmir was necessarily limited in point of time and purpose.
But I'll tell
Time, the framing of the constitution for the state, purpose, once that purpose was over, it had to come to an end. That's your submission.
and one of the proviso, and not just one judgment, which I'll just give your lordship the citation, that it is a principle of construction that unless clearly indicated, a proviso would not take away substantive rights or powers conferred by a section or a subsection. That's Madhu Gopal's case, and the citation is in my written submissions. Paragraph 7.
Just give us the volume, PDF
Yes.
page and para.
But I've annexed it to my note. But if your lordship wants it in the PDF,
Give it to us here, we have taken it.
I don't think
You
it's
don't have
the-
to flip.
it's not in the PDF. I'm not.
It's not,
It's not in your lordship.
Case law PDF.
case law PDF.
It's a very short judgment, literally 2.5 pages.
Anyway, GP Singh's interpretation of statutes, a whole section on how to construe a proviso.
Yes.
Sometimes it's explanatory, sometimes it's an exception, it's clarificatory.
But the principle seems to be that unless clearly indicated, it would not take away the substantive rights conferred by the main section.
All right.
Not just a look at 373, and then I take you to my submissions on this most important point.
Yes.
Now, the Constitution and its provisions have to be looked at the perspective of people drafting it in 1950. Well, in 1950, when they did not know who the ultimate constituent power would be in Jammu and Kashmir. Essentially, what was 370? 373 which talked about the article ceasing to be operative altogether. Because it was the terminus of of the entire article, that article required the constituent power on behalf of the Union, acting on the one hand, which is the President of India, qua 370 and Article 3, qua Jammu and Kashmir through Article 370, he was acting as a constituent power. And on the other hand, the constituent power for the state of Jammu and Kashmir at that time was the Constituent Assembly. All documents from 1948 to 1950, all constitutional documents indicate that a Constituent Assembly, for the purpose of framing a constitution, was necessary, and that was the way forward, which is why Article 373 referred to the Constituent Assembly. But that didn't mean that once the Constituent Assembly completed its task, which was the task of framing the Constitution, that Article 373 would have no meaning, it would be ocious. Now, on the contrary, the COs issued from 1948 onwards, and now this is important, indicate two things. I'll just take a lot very quickly through those COs now.
What do they indicate?
Yes. First, they indicate expressly that the Constituent Assembly and the Legislative Assembly, insofar as it applies to Constitution of India, are synonymous. In other words,
come again, the Constituent Assembly
and the Legislative Assembly are synonymous. I'll point out that expressly.
Where do you get that from?
From the various orders right up to 58. That they are to be read as the same. They are to be read as the same. Now, your Lordship may kindly see straight away the first one, which is CO10. CO10? What's the date? CO10, 26 January 1950. Now, this was the same time as the Constitution. Adoption of our Constitution. 26 January 1950. This CO CO.
So what part of CO10 are you relying upon?
Second schedule. Is it the PDF page?
Just give us the volume and page,
yes,
just so that we have it at one place.
Documents, volume 3, PDF page 7.
What does the second schedule do?
Now, the second schedule says, Articles 54 and 55 shall apply, subject to the modifications. Now, Articles 54 and 55 refers to the elections for the President of India.
What's the PDF page number?
Yes.
Page 7.
Page 7.
7. In documents, volume 3.
Volume 3?
Yes.
Yes.
This is in column 3 of the second schedule. That the reference to the elected members of the legislative assemblies of the state and to each such, has the Lordship got it, man?
Yes.
And to each such elected member shall be deemed to include respectively a reference to the members of the Constituent Assembly of the state.
Because there was no legislative assembly at all.
No legislative assembly. I'll show you. There was no, absolutely right. There was no legislative assembly at that time. But even when there was, so look, that's the whole point. The point is, it was deemed to be a legislative assembly for the purpose of our constitution. Why was this necessary? In 55, they were trying to get members of the Legislative Assembly of Jammu and Kashmir.
All right, which is the next point? Which is the next article?
The next order. So by a deeming fiction, the Legislative Assembly members were the Constitution.
Here's the next one because we are now 5 minutes short of the.
Yes. Then my lord, the next one is CO 39. That's at PDF page 10. See, volume 3 again, PDF page 10.
CO 39.
PDF page 10.
Yes.
Reference to the elected members of the legislative assemblies of the states and to each such elected member shall be deemed to include respectively a reference to the members of the Constituent Assembly of the state and to each such members. In CO 48, which is the next one, I'm running through it now, and this was in 1954. The date of CO 48 is 15th May 1954. Now, in this CO,
that CO you're saying?
So that's about volume 3, PDF page 13. And I'm reading at page 18.
That is CO number?
48, dated 15th May 1954.
Right, that's a 54.
Yes.
Page 18. All right.
Now, in this CO, for the first time, previously it was done by COs. But for the first time, Article 367 was amended.
Right.
As applicable to J and K.
How is it relevant for your argument that Constituent Assembly means Legislative Assembly?
Because that's what the Union of India has done. They've amended 367.
Clause D.
Yes, yes. That's CO 272, which is under challenge. The same procedure was done, undertaken in 1954. For the first time this was done.
This was also pointed out to us by, I think, the learned solicitor.
In fact, that's in his list of days. It's the first exercise of 367 power.
But it was even, yes. But even earlier, they were synonymous. The Legislative Assembly and the Constituent Assembly. It emanated from 1948.
This 14th of May 1954.
Yes, 15th of May 1950.
Right, when there's no Legislative Assembly in Jammu and Kashmir.
No, it's not. But now an amendment is made that they will be the same. Even when there's no Legislative Assembly. And now we are not talking about for the purpose of a presidential election. This is now for every purpose.
All right, which is the next CO?
Then, my lord, your lordship might just see a provision in the Constitution of Jammu and Kashmir, 85(2), 85 subsection 2. This is at PDF page 56, volume 2.
PDF page?
PDF page 56. Until rules are made under subsection 1, the rules of procedure and standing orders in force immediately before the commencement of this constitution with respect to the Constituent Assembly, while discharging the functions of the Legislative Assembly, shall have effect in relation to each house of the legislature. There was only one, subject to such modifications and adaptations as may be made therein by the Speaker of the Legislative Assembly or the Chairman of the Legislative Council, as the case may be. My Lord, substantively and in matters of procedure, the Constituent Assembly and the Legislative Assembly. In fact, what emanates from all this is that the Constitution.
But Mr. Jetnani,
Yes.
the fact still remains that after the Constitution of Jammu and Kashmir was framed,
Yes.
on 26th of January 1957,
Yes.
Article 367 4D was again amended.
Yeah.
So delete clause D.
Yes. But my Lord,
So that equivalence between the Constituent Assembly and the Legislative Assembly ceases the moment the Constitution
Yes,
of Jammu and Kashmir is framed.
Lordship is absolutely right. Now I'm coming to that last one in 58. That's the last piece. But my Lord, what happened is.
That you will find at your volume 3, page 25.
Yes, Your Lordship is at page 25. And that's. The point is, all this shows that the Legislative Assembly, and why was this deleted? This was deleted because after the dissolution or the extinction of the Constituent Assembly, the constituent power in Jammu and Kashmir was now the Legislative Assembly. The power of amendment, in Article 368, it's in virtue of its being a constituent power that Parliament can amend. This is also recognized by at least 3 judgments in Indira Gandhi's, Nehru's case with Raj Narayan. I go back to the beginning of what I said, right at the outset, that the idea was that 373 being the final step, after which Article 370 altogether ceased to exist.
The only distinction is that a legislature which exercises the power of amendment is not a Constituent Assembly. It's exercising a constituent power.
I agree it is. But otherwise, the alternative interpretation would be that abrogation ceases to exist. You can never abrogate Article 370. That would be the alternative conclusion. We have to see why Parliament amended to Article 370 through 367 in the manner which it did. That's the whole challenge to 272. That is the whole challenge. And it did so because not only was it synonymous for they wore 2 hats. The Constituent Assembly wore 2 hats. The same people, the 75 people who constituted the Constituent Assembly in 1951 when it was convened, were the same people who were also members of the Legislative Assembly.
Argument of the learned solicitor is that independent of the amendment of Article 367,
yes,
370(3) and the exercise of that power still stands.
Of course it stands.
And it still survives.
Because I'll tell your Lordship why.
Have to go as far as, according to him, he has not pitched it. Though he said, look, 367 has also been used in the past.
Yes.
The 3 times it was used.
Yes.
But he has said, independent of 367,
it can still be done. Look, which is why I come to my next point. And that's one of the 367. They became the successors. They were certainly the successors. If there was any constituent power which could replace the Constituent Assembly in the proviso, it was certainly only the Legislative Assembly. Now, your Lordship is right, 367 could not be the source did not necessarily have to be the source for that replacement between the Constituent Assembly and the Legislative Assembly. Did not have to be a source. But it was implicit in any event. All 367 did, or the amendment to 367 did, by CO 272, was to recognize an implicit position. It was not only synonymous for a substantial period of time, but it was a successor. And CO 272 did not make a substantive change. It made a change it was a clarificatory change. which was already inherent, which was already implicit in Article 373 proviso.
All right, anything else, Mr. Jefflani, now?
So now the Damnu's case applies. Please one look at Damnu to consolidate this argument.
Damnu we have seen, we'll have a look at it.
Just some paragraphs with special emphasis.
Which are the paragraphs? Just give us.
Yes, I'll give a lordships the paragraph. So paragraph 25, oh no, I put it in my list. Lordship, just gives me a minute. Yes, my lord, the factual situation, which my lord makes the question of law decided clearer, is in paragraph 6, 1, 7, and 8.
Damnu.
Of Damnu. That's the factual situation. But if your lordships recall, it was that change. It was that change of Southern Riyasat to the governor of Jammu and Kashmir. And my lord, the findings are at 19, 22, actually 19 to 28. 19 to 28. And although 367 was upheld by that constitution bench, the amendment to 367 was upheld by the constitution bench on the ground that it was merely a clarificatory. It was not an amendment of substance. So also here, I bring my submission within the four corners of Damnu.
All right.
That this was inherent.
Anything else, Mr. Jefflani?
No, well,
because now the second point you have covered is.
And as my learned friend pointed out, that Damnu also refers to it. Damnu says it's sought in aid of its the judgment article, section 18 of the General Clauses Act.
Yes.
So, my lord, General Clauses Act applies because it's my contention that the Constituent Assembly is the successor. The Legislative Assembly is the successor, and section 18 of the General Clauses Act will squarely apply, as it does. So the powers vested in the original authority will devolve to the successor authority. In this case, the Constituent Assembly, the Legislative Assembly.
Thank you, Mr. Thank you, Mr. Jefflani. Yes, Mr. Guru.
Made these. I appear in IEA Melod's 9596 in WP Melod's 1037 of 2019. Melod's, just a minute, Melod's aside.
Who are the applicants?
The applicants, Melod's, are persons, displaced persons from that portion of Jammu and Kashmir, which is now called Pakistan occupied Jammu and Kashmir. They represent that set of people, Melod's, and their interests. These are the interveners. With prejudice to my time limit, which my lords have given, just an aside, my lords, I'm reminding myself of being that apocryphal son-in-law under Hindu law, my lords, which Sir Alladi referred to. Apparently, my lords, there was a very intricate problem of Hindu succession under Mitakshara and Dayabaga law before an English judge. The questions were getting so complicated that the judge tongue-in-cheek asked Sir Alladi, what would the son-in-law get? I believe Sir Alladi said whatever he is able to lay his hands on. That Lords, seems to be my position in terms of Lords, both time and submissions to really.
So what are the key submissions?
Key submissions, I'll refer to this, Lords. The rights perspective is probably the decisive factor in determining, my lords, the tenability of the challenge which has been mounted by the petitioners. In other words, my lords, the rights perspective will trump or override all or any contentions or allegations of processual infirmities. And the reason why I'm making this submission is this, my lords. Whether it be these intervening applicants or any of the other intervening applicants whom Mr. Salve represented, Mr. Giri represented, or for that matter, Mr. Jethmalani represented, they represent a cross-section of people from Jammu and Kashmir who have suffered discrimination and loss of rights. Therefore, they impugn COs which make provision for rights for such people across the spectrum. The validity will have to be seen in that perspective and in that light. That's my submission for my lord's consideration. For example, my lords, these intervening applicants whom we are referring to, they are probably, my lords, the first victims of the problems which occurred during partition. When the aggression took place and the incursion came, these are the persons who were displaced by force of circumstances from those areas, Mirpur, Gilgit-Baltistan and all those places. They moved therefore to other parts of Jammu and Kashmir and to other parts of India. Now, what is really the problem that they have suffered over the decades now? Because of Section 6 of the Jammu and Kashmir Act, Jammu and Kashmir Constitution, and 35A of the Constitution of India is applicable to Jammu and Kashmir. 6 purported to set out who permanent residents are. (35A) introduced, my lords, by constitutional order in 1954. CO 48. That, my lords, provided that permanent residents, as defined in 6, they will get certain benefits. And the fact that persons who are not permanent residents will not get those benefits cannot be called in question as a matter of justiciability.
Guru, just one clarification.
Yes, Manoj.
People who came from the Pakistan occupied Kashmir,
Yes.
they were not given rights under 35A?
No, for the reason why, I'll tell my lords why. Because that referred to permanent residents. Permanent residents as defined in the Act is any citizen of India, but subject to 3 important riders. Rider number 1. The person must be a state class citizen 1 or 2 as of 14th May 1954. 1. 2, he must be ordinarily resident in the state of Jammu and Kashmir during a period of at least 10 years prior to that date. So the date is shifted back to 1944. That therefore, my lords, meant that even those who were there citizens in Jammu and Kashmir in their own right, because of the external aggression during September, October of 1947, they are excluded. That's where the pinch is, my lords.
If they had settled down in other parts of the country, they would have got citizenship.
No, they would have had to be only
other parts of the country.
Yes, they won't get. If you're in Jammu and Kashmir, yes. But if you went to other parts of the country, you won't get.
Sorry, you're saying
Yes.
the other way around.
May I show 6, my lord?
You're saying the other way around.
No, may I show 6, my lords? Can I show 6? Give me 6. Just give me 6.
Jammu and Kashmir Constitution is in part 1
Yes.
of the document. Part 2. Part 2.
Volume
Volume 2.
2, my lords, page 18.
Well, I'm sorry to interrupt. There are 10 petitions here which challenge 35A. Well, those have to actually be de-linked because we're not here concerned with the challenge to 35A. We're concerned with 370. So, well, all that is fine, but that's not to be decided by your lordships. If this is upheld, if what the union is saying is upheld, this is unnecessary.
That's right.
Doesn't exist.
This is simple. Therefore, we are going into this.
I'm only saying, Malaz, this is only
Let's-
take up the
let's-
time of the court. That's all.
Every person, I'm at, my lords, volume 2, PDF page, my lords, 18. Every person, may I read it, my lords, is deemed to be a citizen of India under the provisions of the Constitution of India, shall be a permanent resident if on the 14th day of May 1954, he was a state subject of class 1 or of class 2 or having lawfully acquired immovable property in the state has been ordinarily resident in the state for not less than 10 years prior to that date. Any person who before the 14th day of 1954 was a state subject of so-and-so, and who having migrated after 1st day of March 1947, this is an anomalous provision. I'll just show that, my lords. So the first part is 6.1. That talks about two dates, 1954 and 10 years prior to that. Second,
it's an alternative. A and B is an alternative.
that's right. Or, that's right. That's right. But then in terms of actual application, they have always been applied together. All these are persons.
They have been applied, treated as cumulative.
Yes. You are outside Jammu and Kashmir. You don't get it. In fact, I've given in my application, my lords, the case of how 8,700 people and odd people left that place during that time, during partition. Today, my lords, after the promulgation of the impugned COs, at least 23,000 people have received domicile certificates. About 24,000 people. We have mentioned that in our submissions.
So state subject of class 1 or clause 2
Yes.
is defined in clause 3.
Yes.
Subsection 3.
Yes.
Namely, that refers you to
1927.
So
That's right.
you're out there.
Yes.
You don't come in there.
No. In fact,
Clause 2.
no, because by 47, by 44, what happens is this, my lords. They expect you to be holding property as of 1944. And even though I qualify, in fact,
Let's say in POK, they're not governed by clause 3 of section 6?
no, my lords, what will happen? They will be governed by clause 3. That's why I'm saying it is applied cumulatively. You should be a state citizen, state subject of class 1 or class 2, and you should have been holding.
It says or.
No, but cumulatively it's being applied where you should have held property as of 44.
But then, Mr.
No, all I'm saying is this.
Mr. Kishan, I don't think 2 can be read as cumulative because it imposes a condition of owning a movable property.
No, I follow.
That owning property.
No, I understand. But the fact of the matter is.
It cannot be.
The fact of the matter is, my lords, they were entitled, but they have not been provided. That's the actual position.
Only thing is because under A and B, if you're not under A, if you're class A and class 2 citizen, then you have to go for 1927.
1927.
Get documents of 1927 will be very difficult for anybody.
That's another aspect. Absolutely. I bow down to that.
Now in clause B, prior to that date refers to which date? 14th of May, 1954?
Yes, that's right. 1954. That 14th of May, 1954.
Yeah, for clause A, subsection 3 applies.
That's right, 27.
There is a 1927 order.
Correct.
For clause B, you have to own property and you must have been ordinary resident at least for 10 years prior to 14 May 1950.
I vote on.
Right?
And that
so
date
from 14th of May 1944 onwards.
That's right.
Comes within the
should have held property, and that 1954 date, my lords will recall, is the date of CO of 1954.
That's also very odd because
yes,
to say that you must own a property to get citizenship.
Exactly. Now, one more thing, my lords. One more aspect, my lords. Please have a look at 2, section. Yeah, that's right. Yeah. It's a
you're really trying to say is you're supporting the CO 272 and 273.
Correct.
By pointing out the anomalies which would otherwise arise as a result of Article 35, Section 6 and 35.
I bought on the challenge, my lords, would really mean that they want to resurrect, amongst other things, this and 35A. That's the point.
Of course, challenge to 35A has.
It stands. But
kept aside.
I bought on, my lord.
Application to assist. Otherwise, that challenge has been kept aside to await the fate of the decision.
I bowed on, my lords, but then I am saying that this is important.
A provision which doesn't exist as of now cannot be challenged.
No, that's true. The effect of upholding the COs is to ensure that, my lords, this anomaly doesn't exist anymore. I am respectfully submitting, my lords, that I am placing this submission from the perspective of rights which are being made available by the impugned COs. That's the point I'm making. One more anomaly to add to what fell from my Lord Justice Khanna may have a look at it. Section 2, subsection 2. Any person who before the day of 1954 was a state subject of class 1 or class 2 and who having migrated after the 1st of March 1947 to the territory now included in Pakistan, returns to the state under a permit for resettlement in the state of a permanent return issued by or under the authority of any law made by the state legislature shall on such return be permanent resident of the state. So you make an exception out of this by saying those persons who may have gone to Pakistan, if they come back, they'll get the benefit.
Any persons also who was.
Yeah. The anomaly is writ large.
No, this included in Pakistan will not include Pakistan occupied.
No, it won't. That they are very clear.
It will not include Pakistan.
No, it won't. That's why a separate provision is brought in.
It will be portions other than
POJK. There is one other, my lords, very ironical aspect. The Jammu and Kashmir Constitution makes provision for seats for POJK in the assembly, but says because it is under 1 minute.
Time is up.
I know, my lords. That's why. Now there are two other perspectives I'll place and then I'm done, my lords. In fact, this is something which nobody has referred to. That's the reason why I'm even troubling, my lords, with some of the nitty-gritty of this, my lords. So this is one aspect. 35A, just have a look at that for a minute, my lords. Now, because there's a striking parallel to 31B under the Constitution. Koilo, please see the kind of dilution which took place in Koilo. Just have a look at 35A for a minute, my lords. This will be volume 1, PDF page 99. May I read the words? Notwithstanding anything contained in this constitution, no existing law in force in the state of Jammu and Kashmir and no law hereafter enacted by the legislature of the state defining the class of persons who are or shall be permanent residents of the state of Jammu and Kashmir or conferring on such permanent residents any special rights and privileges or imposing any other persons any restrictions as respects employment under the state government, acquisition of immovable property in the state, settlement in the state, or rights to scholarship or such other forms of aid as the state government may provide shall be void on the ground that it is inconsistent with or takes away or abridges rights conferred on the other citizens of India by any provision of this part. Now, 31B, my lords, under the Constitution provides that anything included in the 9th schedule shall be immune from challenge on grounds of violation of Part 3.
Guru, now I also note that in your written submissions, you've really highlighted, what was the anomalies and what has been restored now.
Exactly.
The rights perspective.
That's right.
I think let's go into the
three more things, my lords. I'll take only 3-4 minutes, my lords. Now, 31B in Koilo, my lords, very extensively referred to the foundational value of the fundamental rights. Golden triangle of 14, 19, and 21. I've given all those paras in my submissions, my lords. In fact, I've given the extracts of all those paragraphs in Koilo. Now, ultimately, my lord said, you cannot take away judicial review and any law included in the 9th schedule can be tested on the anvil of basic structure. Now, surely you cannot have a position, and that's what petitioners are bargaining for. What was there in the original constitution, my lords, this is the approach of this honorable court. The petitioners can't bargain for a position where the Jammu and Kashmir constitution, which is admittedly inferior, in terms of, my lords, the constitutional governing instrument than the Constitution of India. They have something better than that. This is the kind of importance which has been given under the constitutional scheme of India. In fact, 31B itself, my lords said at one part in paragraph 78, just make a note of it, the validity of 31B was not in challenge and therefore my lords did not go into it. My lords assumed that in Shankari Prasad and in Sajjan Singh it was upheld, therefore my lords didn't go into it. But instead, judicial review cannot be excluded. And you cannot say, by placing it there, I'm making it immune to challenge. That's precisely what 35A purports to do. That's the second part, my lords. Third part, ultimately, my lords, all the nuts and bolts and the nitty-gritty looked at. What does it come down to, my lords? The basic structure is the ground norm. That's the touchstone on which any constitutional decision-making has to be considered. The validity of any constitutional decision-making has to be seen. Today, what are they, my lords, arguing in terms of basic structure? At the highest, apart from, if I may say so, diffuse arguments of fraud on constitution. Two square features which they want to invoke, my lords, in various forms. One is federalism. The other is, my lords, representative government. So far as representative government is concerned, I think that already the solicitor has pointed out, it's a Puducherry model, there is representation. So far as federalism is concerned, the highest that they are able to put it on is some kind of a derivative form of federalism based on what my lords have said in the 2023 NCT judgment. That's the highest they want to put it at, where they say that my lords are referred to an asymmetric federalism. Paragraphs 40 and 41 of 2023, my lords have been given, the citation is there in my notes of submissions. What they want to say now is, asymmetric federalism has been recognized. Now please stretch this and say, the multisymmetric federalism of 370 should also be taken to be a basic feature of the facet of federalism. That's the argument. I'll give the page numbers of Dr. Dhawan's arguments. Page 280, page 211, volume 1 of submissions. After extracting from my lord's decision in NCT in 2023, they say that this now has to be stretched further to say multi-symmetric federalism. There, para 40 and 41 of 2023 at the risk of carrying coal to Newcastle, my lords. My lords, interestingly, have referred to 371 and all those provisions for various states by way of special provisions. My lords there refer to how they are special provisions in 371. And it is on that basis, by relying on the marginal note, my lords have pointed out how constitutionally some kind of asymmetric arrangement has been made. So it is on the basis that it is a special provision in 371. Today, what they want to do is equate 370, which is temporary, with 371 special provision. I hope I make myself clear. Yes, yes. Therefore, that is why I said it's a derivative argument they want to make. 371, my lords consciously referred to the marginal notes and said how these are special provisions, and that's how they provide for special provisions. That cannot be stretched, my lords, to say that it has to be applied to 370. The temporary character, nuts and bolts of 370, all of them have been argued, my lords. I don't want to take the time anymore. I'm adopting those arguments. In the light of that, my lords, I would respectfully submit. In fact, the impugned COs are reflective of transformative constitutionalism. What was argued by Dr. Dhawan, in my respectful submission, the boot lies on the other foot. The impugned COs ensure that the Constitution of India, with all its plenary scope, applies to the state. In my respectful submission, my lords, the challenge of the petitioners is really a contradiction in terms. Because this is a case where the application of the Constitution of India, the plenary document, is sought to be challenged. The effect of the COs is to ensure that the entire Constitution applies to the state, with all Part 3 rights, with all the other provisions. And even on federalism, my lords, there is one other portion in the opening remarks of Dr. Ambedkar while placing the draft constitution, my lords, before the assembly, constituent assembly.
Mr.
I've
Giri has
extracted.
extensively read it.
No, there is another portion apart from what Mr. Giri read. So I've extracted that in my submissions. My lords could have a look at that.
We'll see it.
Therefore, my lords, in sum and substance.
Thank you, Mr.
In sum and substance, my lords, this is for perpetuation of vested rights. And the COs, my lords, make provision for realization of rights under the constitution. I'm obliged.
Thank you, Mr.
Yes.
Who are you appearing for?
I am for the writ petitioner who had filed the writ petition in January 2018 against the effacement of all articles in respect of me in relation to Jammu and Kashmir. Part 3, effacement of Part 3, a core value from the Part 3. I challenged that before this court, and that has been tagged down. Enough has been argued, but I am arguing for class, that's Radhika Gill versus Union of India.
Which is that?
Radhika Gill versus Union of India, and my synopsis is at page, the compilation is 426. I'll take only 2 bits, my lord. This Radhika Gill and the other person belongs to that class who are descendants to those persons who have been lifted from Gurdaspur to Jammu and Kashmir in 1957 to handle the sanitation problem which had arisen on account of the long strike in Jammu and Kashmir. So they were settled in the outskirts of Jammu and Kashmir, and my lord, that now has converted now with the passage of time. Those are the slums, no property rights, etc., no education rights, etc. Now, my lord, your lordship may kindly see my prayer. The whole effacement of Part 3 in relation to Jammu and Kashmir, I have challenged in my writ petition. Your lordship may kindly see the Solicitor General referred to Article 14 effacement also. Your lordship may kindly see 35A, Clause A. What exactly it does? It does one thing, my lord, delegating the power to the state legislature to define the permanent resident and not challengeable. That's what, my lord, the delegation has been done to the state government, state legislature, my lord, in this class 1, your lordship, defining the class of permanent resident and delegating it to state legislature and not challengeable. So, my lord, your lordship have not allowed such a delegation to the state government so far as the Part 3 aspect is concerned. So that's what the solicitor said, that core value of Article 14 has also been taken away. And with the aid and assistance of this delegation, Section 6 was incorporated, and this is nothing but a homage to defined ancestry and none else. Whosoever is there on a particular cutoff date, I was there in 57 only, my lord. So my predecessors were in 57, and we were there, and now we are denied. I am born there, and at least no fundamental rights are available to me. That's why I challenge that right to education. Section 6 has also been challenged in that petition. Now, your lordship, I am now, so far as my synopsis is concerned, paragraph 17 and subparagraphs have dealt with 3 aspects. One is the powers precedent are constant in nature. The lordship may kindly see paragraph 7, subparagraph B.
That's argued.
Now, one thing. Relationship between 368 and Article 37.
That's been also argued.
No, yes, I have taken this. I have taken this here. That.
Thank you.
Thank you. Anything else? Yes. Yes. What about you?
I am appearing in, my lord, I number 153121.
I number?
153121.
15153.
153121 of 2019. That's Roots in Kashmir. Roots in Kashmir is an organization which is espousing the cause of Kashmiri migrants, now called displaced persons, since 1989. There are 5 lakh people.
What is the
That's one petition. Number 2 is Dr. Charu will Khana, that's a substantive writ petition in 2017, 369. Lord, that is, just give me number. What's the number? 396 of 2017. Submission is, my lord, I am allowed given detailed written submission that are conjoint written submission, my lord. Volume 3, page 444 to 456. And, my lord, for convenience, my lord, I have filed a small note, 3-page note, my lord, which was taken on record, my lord. I read it, my lord.
All right, we'll have a look at it, but you can just sort of in 1 minute just highlight what is the central point.
My lord, I'll say, my lord. I'll say, my lord, the instrument accession dated 26/10/1947, my lord, is final and issue of proclamation, and the Article 1 and is completely applicable, my lord. So it has, it's being an integral part of the my lord, India, domain of India, my lord. Then, my lord, I say,
That
my
is
lord,
something which has not been argued.
my lord, it's not, my lord, it's not, my lord. I say, my lord, with respect to the Article 370, which has been raised, my lord, herein, that the devolution of power of Constituent Assembly is transferred to the Legislative Assembly, as there is no Constituent Assembly as on 57. Therefore, it's not the...
That has already been argued so many times.
My lord, it's not, my lord. It's not, my lord. Concurrence given to the government of the state, but also repository. My lord, ratification has been done to the parliament. So absolute majority, parliament has rectified the legislative. One is that, my lord. Two is, my lord, and my lord, it's not a basic structure. As my lord held in, my lord, I am going to.
Got the point.
I have, my lord, relied in my lord. I relied on my lord 1973 for SEC volume 15, my lord, in Keshavananda Bharati of Justice, my lord, Justice Khanna. He has given that, my lord. And, my lord, then Bomai also, it's not a federal, it's a quasi-federal, my lord, state. Then Puran Lal Lakhanpal and, my lord,
that is now being covered.
modification. My lord, I had added one judgment, my lord, because I could hold that. That is, my lord, S. Sant Singh and others versus State of Jammu and Kashmir, reported in 1959, Jammu and Kashmir, page 35. That's a full-fledged judgment, my lord, which deals with modification clause of, my lord, Article 30, my lord, Article J&K Tenancy Act, my lord. That is AR 1959, Jammu and Kashmir, page 35. Dealing with the challenge to provisions of Jammu and Kashmir Tenancy Act inserted in 9th schedule was upheld and did not violate any of the fundamental rights conferred under Article Part 3. See, this is, my lord. Then Coelho, as my lord said, that it's not a fundamental, it's not a violation of fundamental rights under Article Para 102. My lord, Coelho is that page, my lord.
Coelho has been argued so many times. Everybody has referred to Coelho.
Then, my lord, we have very less time, my lord. That's why, my lord, I'm just going to all these things.
To Mr. Dwivedi.
Indra Sani, my lord. Indra Sani, my lord. 35A, my lord. I have challenged the substantive writ petition, my lord, in 2017, which a notice was issued, and this was referred to the Constitution bench in that time only, my lord. Then it was tagged along with this, my lord. So I have 4 judgments to cite on, my lord. Indra Sani, that's equality. 19. My lord, what has happened in this? My lord?
You put it in your note.
My lord, I said, my lord, 27 and 32 notifications.
We have 3 minutes now. Let's hear some other people.
I'll take 3 minutes. I'll take 3 minutes. I'll take 2 minutes. I'll take 2 minutes.
No,
27.
You have to close at.
My lord, 27 and
Yes,
30.
Mr. Banerjee, what do you have to say?
My lord, I'll say why.
I am.
We'll read your written submissions.
Then
I am appearing in IA 146764, my lords.
My lord,
Just petition from 20.
My lords, enough.
No, that absolutely not. You have to conclude. We have to conclude by lunch. I mean, we had made that clear yesterday.
my lord, my 1 minute they'll take, my lord. My lord, I'll say, my lord.
Mr. Judge, we had said that, look, we are going to conclude at 1 o'clock. We had requested everybody to so structure their arguments that the others who follow have time. We are not going to cross 1 minute after 1 o'clock for
yes,
this side.
my lord. I'll read it affidavit, my lord. I'll read the affidavit, my lord, which I mentioned in the morning, my lord.
You can argue for the next 3 minutes, but you know what the consequences. We are rising at the stroke of lunch.
My lord, I read. My lord, let me read the affidavit.
See, this is not fair. You said
This is
I will give my
filibustering.
half an hour to Mr. Dwivedi.
My lord, half an hour to me, my lord. I could curtail my half.
Mr. Judge, you
Half an
specifically
hour.
said
Gave your half an hour to.
My lord, can I read
that
the
I'm
affidavit?
giving my half an hour to Mr. Dwivedi.
My lord, can I read my affidavit, my lord?
We'll read it. What is
Read it, my lord.
We are rising at 1 o'clock.
In my affidavit, my lord, I'm making only one submission, my lord.
The
Let
element
Mr.
of
Lone
civic
make a statement
consciousness
or
must also
affidavit
apply
that
to legal arguments
that
and
he's a citizen of India and he doesn't, my lord, support terrorist states, my lord. Let him put an affidavit, my lord. Mr. Sibbal, learned counsel is here, my lord.
All right, 1 second. Just 1 second now. Just 1 second.
Please.
Mr. Agarwal, what point do you want to make? Just formulate it. Come.
Affidavit, my lord.
Diversity, the element of documents,
My lord, only one thing, my lord. Mr.
Your time is over.
President of the bar is
Your
here, my lord.
time is
Jammu Kashmir president. My
Your
lord.
time is over.
My lord, I was appearing for Jammu and Kashmir High Court Bar Association. My lord, president of the bar is here, my lord. He wants to say something. That's all, my lord. I am curtailing my argument.
We are in charge of whom we will hear.
You are not in charge of who will follow you.
Well, I don't.
Mr. Kanu Agarwal.
Okay, that's, well, I leave it to Allah.
That I have submitted. Federal diversity, my lords, Dr. Dhawan sought to rely on the judgment of R.C. Podial. If my lord sees, to my understanding, federal diversity in the Indian Constitution exists on a two-dimensional plane. At the center would, as far as I understand, would be the classical states, would be the classical understanding of a state, the state which has fully governed by Schedule 7 and other provisions of the Constitution. To the right of it would be states which have limited special features, would be states like the limited features like Gujarat or Maharashtra, all taken through by Dr. Dhawan. Thereafter would be states which say fall under the 5th schedule and the 6th schedule, and some other states which have further special features. To the right end of it, perhaps, was the erstwhile Article 370. What the petitioners forget, my lords, is that there is a scale to the left of it as well. The scale to the left of it is the union territories with legislature, is the union territory of the GNCT of Delhi, and further, perhaps, pure and simple union territories. Therefore, federal diversity, my lords, it's undoubted that diversity is a constitutional fact, but not all constitutional facts can be elevated to the level of basic structure. When we adopt the identity test in terms of identification of basic structure, not all constitutional facts become basic structures. R.C. Podial was relied upon to further the argument that this diversity, a manifestation of which was Article 370, erstwhile Article 370, is a part of basic structure. Incidentally, my lords, para 128 was read in R.C. Podial. If my lord sees the last 3 lines of para 128, I think that those last 3 lines itself completely demolish the case of the petitioners on federal diversity, because those last 3 lines itself indicate that these provisions which were in consideration in R.C. Podial were for a limited transitional period. The word transitional has been used. Therefore, my lords, as far as the fact that federal diversity may be integral, it would not necessarily lead to it being a basic structure. The method and the methodology adopted by the union, whether under 368 or 373, has been fully taken care of. I don't wish to address it further. The second point is on, my lords, Constituent Assembly and the nature and the nomenclature of Constituent Assembly. Mr. Gopal Subramaniam specifically highlighted that there are no hierarchies. That was his assumption, that there are no. At a normative level, that's an absolutely correct statement. There cannot be any hierarchies in Constituent Assembly. However, there are not many things that move on a normative level in Jammu and Kashmir. There are 3 facts in this regard that my lords need to see. There are 2 kinds of constituent power. One is original constituent power, and the other could be derivative constituent power. It was on this jurisprudential basis that Keshwanand Bharti was delivered, and thereafter other judgments, which state that the original constituent power is always with the original Constituent Assembly, the plenary power. But derivative constituent power is something that is always with further legislatures, the parliament in this case. Therefore, the question that we need to interrogate is whether the Constituent Assembly of the Jammu and Kashmir Constituent Assembly had any original constituent power. The 3 facts, which according to me clearly point towards the fact that they had no original constituent power, were A, it was established under the proclamation of a Maharaja that had already signed an instrument of accession. Number 2.
Just one second.
It's there in the 3 page.
Yes.
Number 2, the Maharaja had already issued a proclamation dated 25/11/1949, recognizing the supremacy of the Indian Constitution. And number 3, unequivocally, Article 1 was in force. So on the date in 1951, when the proclamation to establish the Constituent Assembly of Jammu and Kashmir was issued, the Maharaja, who was not a sovereign, could not have passed a better title than what he had. If he was not a sovereign, the Constituent Assembly of Jammu and Kashmir could never have been a sovereign Constituent Assembly, could never have established a sovereign constitution. The suggestion from the other side is that under 370 sub-article 3, they could have severed their ties with India at the time of dissolution of the Constituent Assembly. My lords, I submit that is an absolute impossibility as far as the Indian Constitution is concerned, because Article 1 would have applied to them irrespective of the nature of Article 370.
Which is the page of your written submission? In the
That's page 2.
No, in the volume 3?
My lords, that is not there in volume 3.
I cut those.
My lords, if my lords allow,
All right, thank you.
Please, Malad. Just one more aspect, Malad.
Yes.
If the JNK Constituent Assembly had no original constituent powers, it automatically exercised only derivative constituent powers. If it is exercising derivative constituent powers, it is akin to a legislative assembly. Malad, one of the letters that was highlighted by Mr. Shankar Narayan was a letter by Rajendra Prasad to Mr. Nehru. Malad, may remember 1952, 6th of September, I think, 1952 by Rajendra Prasad. That letter finds mention in Mr. Noorani's book at volume 20, page PDF 222, I believe. Mr. Noorani has done a lot of research. He should have also pulled out the letter which was written by the then Prime Minister, Mr. Nehru, in reply to the letter of Rajendra Prasad. Mr. Nehru wrote a letter dated 7/11/1952 to Mr. Rajendra Prasad on a host of issues after Mr. Rajendra Prasad had also written a letter to the then Home Minister K.M. Munshi. And he highlighted the fact that how this issue has been discussed with the law officers of the union at the highest level with Mr. Gopalaswamy Iyengar and with other people. I have annexed it to my note, my lords. And therefore requested the president, requested being the word, requested the president to consider passing the CO. That was on 7th of November 1952. Within 8 days, my lords, the learned president passed the CO 44, which was 15/11/1952 under 373, thereby changing Maharaja to Sadar Riyasat. Therefore, my lords, I think the SG had also pointed it out that actions speak louder than words. That is all that I
Yes, Mr. Vikram.
My lords, I'll just make a small submission. My lords, my submission is this. My lords have seen the original constitution. The original constitution.
Biju, move towards the center.
Yes. My lords, the original constitution, there were transitional and temporary provisions. It wasn't, the special provision was subsequently added as an amendment at a later point of time. So the original constitution in this chapter was as to temporary and transitional provisions. So the very fact that this is taken to be a transitional and temporary provision means that this is the entire objective of the original part. Subsequently, a large part of it, my lords will recall, has from 75 to 91 have now been amended out. So the original intention of including 370 in that chapter, and it was in the genus of that, this was a transitional provision. And my lords will see 391 and 392, there were presidential powers which were given to make amendments.
Thank you, Mr. Banerjee.
My only submission is this was permissible to
This has been already argued, Mr. Banerjee.
Thank you, Mr. Banerjee. Now, Ms. Pathak, come along, come forward. 1 second. We'll call out. We're calling out people. Don't jump the gun. Yes.
1 minute.
1 second, Biju.
Yes, I'm sorry.
Yes, Ms. Dave. What do you want to?
I'm appearing in an IA 171722 of 2019.
So what's the point, tell us?
Well, the point that I'm making is, the permanent residentship, no one has talked about the rights of the women that were taken away. So the permanent residentship would not come to the women who have married outside the state of Jammu and Kashmir. So, my lords,
that was set aside. That was ultimately constitutionally.
Yes, my lords, state of J&K versus my lords, Dr. Sushila Sahani 2002 judgment. In fact, the full bench of the Jammu Kashmir High Court held that they will have permanent residentship even if they marry outside. But the state then, my lords, the learned AG there made a statement that they will not get, in fact, my lords, the right to employment, right to scholarship, as well as the right to hold immovable property was taken away if you marry to a person who is outside the state of Jammu and Kashmir.
Thank you.
Well, it's my written submissions.
Yes, we'll take.
I have.
What is your page of the written submissions?
I'll give it to the learned court master, my lords. We had submitted to the nodal council.
All right.
2 pages only, my lord.
Volume 3, right?
Yes, my lords. There's one,
Yes, Biju.
my lords. We have got these rights now after 2019. Can a writ petition filed under 32 take away fundamental rights given to the other citizens of the country, my lords? Is my respectful submission. I'm obliged, my lords.
Yes, Biju.
I'm appearing for my client who is a retired major. He dedicated his substantial time in the area in question, which is J&K. And my lords, my IAS 171000 of 2019 petition civil number 1082 of 2019, my lords. Kindly note this because my.
Biju, just make a point now.
Yes, my lords. 171000 of 2019 is WPC number.
We'll see that. You just make what.
Just what's the substance? What's the point on substance?
My point is this, my lords. Before that, my lord, page 5152 525 of volume 3, my written submissions, where I substantiate what are the ground realities, where I substantiate what was happening, as my lords already asked. My lords, what is after going again and again, 370, sub-article 3 provides so there is a special provision. And if it is non-functioning, then what is the way out?
This point has been argued.
What is it?
Come on now, tell us something.
What is the next remedy, my lords? My respectful submission, my lords, is extremely clear in the Constitution of India, Article 368(1). Then 2 is saying that, 368(2) says that if so and so articles or chapters, if you are going to touch, or if you are going to touch basic structural principle, then you have to have the ratification of the 50% of state governments. In that subclause 2, there is nothing to do with 370. So 368(1) is starting itself is, my lord, extremely important, that language, that notwithstanding anything contained in notwithstanding anything.
Thank you, we got the point. We got the point. Thank you. Sir, at the back. Biju, there's somebody at the back from Srinagar, Jammu, who is.
This is one area, my lord. Then my respectful submission, my lords, what I did that. Again and again, my lords, I was repeatedly reading my lord judgments from 1950 onwards, at least 5 judgments, which are constitutional judgments, saying that there is every power for Indian Parliament and the President of India.
Thank you.
That I, my lord, separately indicated in paragraph.
We'll see on that. Yes. What is your point?
I'm grateful just for the time. Lords, I'm appearing in 108 and 43 of 2018, Lords. There's an IA filed, Lords, by the Bar Association, High Court of J&K and Jammu. Now, Lords, I adopt, Lord, the submissions of the SG and everybody, Lord, who is supporting this, Lord, CEO. One submission, Lord, if the Honorable Court would permit me, is that whether, Lord, at this 76th year of our association with a country, a question mark, Lord, on our nationality also would not hit, Lord, in the extended interpretation of Article 21. If I would seek the Honorable Court's indulgence, Lord, that whether right to live with dignity, Lord, starting from Maneka Gandhi's 78, would also include, Lord, a right to have a nationality after having lived with the country and identified oneself with. So, Lord, we take pride in being Indians outside of India. But when it comes, Lord, within India, can there be somebody, Lord, allowed to raise a question mark on our nationality? Because, Lord, when I was, Lord, following this, Lord, debate on the VC from J&K, questions like referendum also, Lord, were addressed. Now, in this, Lord, 75th Golden Jubilee, which we say, if, Lord, at this point in time also, a question mark on our identity with a particular nation where we have contributed and will live with pride within India, if this is still, Lord, is hanging in balance, though, Lord, we owe our, Lord, gratitude to the Constitution that this debate is still permissible. But then, whether the Constitution, Lord, can be so flexible as to include a debate also as to a person who has contributed a lifetime. No, this is the 3rd generation, Lord, into it. Now, from 47 onwards, we are now, Lord, in 2023. And in 2023, Lord, if I have to prove to somebody that I am an Indian, whether, Lord, my life is actually a life of dignity, is, Lord, my humble submission. I'll seek honorable bench, Lord, indulgence.
Thank you very much.
I'm grateful.
Thank you.
Lords, 35A is linked to Section 6 of the Constitution of Jammu and Kashmir and is linked to 370. If 272 and 273 is not upheld, what the consequence is that there is a tap on the application of the Constitution of India, including Part 3, which can be turned on, turned off at the discretion of the state government, which by itself is inherently discriminatory, abusive. Yes, which has been therefore, apart from IR Coelho, I think most important is Puttaswamy, where your lordships have upheld the socio-economic interpretation, because for a long time, fundamental rights were essentially social in nature, but an economic angle has been brought about. Our problem is we are being deprived of that. One very brief point, my lords, the consistent position of Republic of India, and I deliberately say Republic of India, before the United Nations Security Council is that there was no sovereignty of any kind, slightest nature, residing with the state of Jammu and Kashmir, neither under international law nor under comparative constitutional law. For comparative constitutional law, there's an opinion of Dr. Ambedkar, which is in my submission, where he said why there is not even an iota of sovereignty with any princely state, including state of Jammu and Kashmir. In international law literature, it is very clear, settled position of customary international law, which was also taken by the Republic of India in the Security Council in MC Chagla's speech, and also Krishna Menon's speech, very clearly spelled out that under international law, there's no possibility of any such constituent, which is an integral part of India, to have any sovereign right. So that is clear. So therefore, no question of Constituent Assembly or Maharaja having any sort of sovereign power. In fact, it was made expressly clear in the Security Council itself by both of them that aspect rests entirely with the Union. So what is being now called as residual sovereignty can't conceptually exist. It contradicts the very idea of sovereignty propounded by Bentham, or even by Max Huber. Therefore, sovereignty, there is only one sovereign. All that they can have is legislative competence, that is also to minimal extent. Apart from that, there was a major argument which was made that instrument of accession had to be approved by JK Constituent Assembly. It wasn't necessary. The only requirement was Section 6 of the Government of India Act. This was the consistent position again put forward by MC Chagla before the United Nations Security Council. Also under section, one very last point, India was the successor state which included princely states. That comes from section 311 of the Government of India Act. Therefore, by virtue of that, India already a singular entity where all sovereign authority rests with the Union and the constituents don't have any other power. To use the phrase of Krishna Menon, they are sub-sovereign entities.
Being Advocate General,
and nothing
for UT.
Yeah.
United Nations. This is past history. There is nothing pending in United Nations or anything. It is our internal.
Yes, my lords. Yes. Only thing I was saying, that's the position, that there's no such internal.
But, being the AG, first of all, I subscribe to the submissions made by attorney and solicitor general and my colleagues on this side. One aspect perhaps need to be brought, but the basic fundamental rights include the health also. And health generates from the health medical education. All judgments, whenever it would come, I am passing a judgment to Lordship just now. But kindly see the plight in J&K. Whenever it comes to the taking a health care, the point would be that we, because of 370, will not allow those benefits which are emanate from Article 21 to flow to J&K. Now I am passing the judgment of this Honorable Court. But whenever this issue comes, this is 1984 where they say, yes, for the rest of the country, that sending 70% of seats and 30 for local is funded. But when it comes to J&K, even this Honorable Court says, we'll wait till the time comes. How long will this medical facilities, which are, just have a look to these judgments. In this last paragraph, the court says, so far as J&K and Andhras are concerned, we are told that there are some constitutional provisions, and therefore we deal. The result was that for so many years, the erstwhile state of Jammu and Kashmir and now UT remain deprived of the basic fundamental rights, including the medical education. So let's just have a look to this.
We'll have a look at. Thank you, Mr. Advocate General. Thank you.
All right.
Holding my
Everyone, 1 minute each. Yes.
Yes, my lord.
Just before I conclude, all speeches, because I know that time, all exercise, understanding and the literature, one word is very important. All leaders, including Mr. Sheikh Abdullah, in unequivocal terms said accession, not the aggression. In the parliament on 8 January 48, everywhere. No blood, even at this stage of 75 years, yet we have to define our relationship with it. But as Article 371, Part D, Part 3, they were discussed so. In all cases, we are the integral part of this great nation, Union of India. All arguments to the contrary are too late in the day when the Constitution of India had all its place, and now it is only academic, otherwise we are a part of that. I'm grateful.
Thank you, Mr.
Lord, the short submission. This amendment A cannot be seen as a silo in light of the larger transformative nature of a constitution. 3 bullet points that come in it.
the violation of rights of those who are persecuted is so extensive, my lords, that it has been recognized as a grave human right violation in 2019. A violation, my lords, which is considered an international crime in international law, therefore attracts customary international law and is a jus cogens norm. So therefore, my lords, when such an acknowledgement does come in, really a case for restorative and transitional justice does arise. So clearly, my lords, those who have been persecuted and they want to go home, it will have to happen that security is ascertained and restorative and transitional justice does arise. So fact-finding missions, truth commissions, transitional commissions, therefore become the norm. Unless and until, my lords, an amendment of this nature does not come in, that takes away the conditions of oppressions that were there and that ensured that they were not only persecuted but had an exodus in 89 and 90 is not taken away, this higher feature cannot really be attained, my lords. So therefore, my lords, I submit that this has to be seen holistically and attributing of responsibility. My lords.
You can put it in your note. It's in your note.
Millards. Now, I'll limit my intervention on just two aspects, my lords. One is the proviso under Article 3, my lords. The contention of the other side was that the requirement of taking the views of the state legislature is a condition precedent. My lords, as the learned Solicitor General has shown already that wherever Article 356 was invoked, this proviso to Article 3 was suspended. Secondly, my lords, the views of the state legislature under the proviso are not binding on the parliament. Your lordships have so held in Babulal Parate's case. Thirdly, my lords, Article 3 is a plenary power. So any interpretation, any construction cannot be given to the requirements of obtaining the views of the state legislature, which denudes from this plenary power. My lords, the second argument is the Rajagopal case, Karunanidhi's case, which was cited by the petitioners, is wholly inapplicable, my lords. That is a one-paragraph judgment, and the finding that is given in that judgment is that dissolution of state assembly will not be a ground to hold that the constitutional machinery has been broken down in the state. Rajagopal case relies on UNR Rao, which is delivered by the same bench of your lordships. In UNR Rao, the contention was that a writ of quo warranto was sought against the Prime Minister and her cabinet. The contention was that since the House of People has been dissolved, and since the cabinet is responsible to the House of People under Article 75(3), the president should dismiss the cabinet. Your lordships rejected this contention and said that Article 75(3) will only apply where the House is not dissolved or prorogued. So this case is wholly inapplicable. My lords, my note is on volume 6, PDF page 50. Kindly consider that. I'm grateful.
My IA is, my lords, 146764, my lords.
Yes, Mr. Bhushan, what do you have to say?
Yes, my lords. I have to say, or make only one summation that this temporariness and permanentness of Article 370 has to be looked through the prism of word further in the preamble of Jammu and Kashmir, read with Section 3 and 147 of Constitution of Jammu and Kashmir also. Even Constitution of Jammu and Kashmir has not given power to itself to amend Section 3, where it is said that it is and shall be the integral part of Jammu and Kashmir Constitution of India. And second is will of people. This was argued strenuously.
Lordship, I appear.
Yes,
for,
Dr. Khanna.
Lordship, I appear for Youth for Kashmir, Pannu Kashmir. We were the people who were displaced in 1990s, whom I represent. Lordship, my first point of submission is when the instrument of accession was signed, that day it was complete and formal integration with India. And
that point has been made. What is the next point?
Lordship, the second point that I wanted to make, that because of 370, there was no economic integration with India. That was we were making. And the other point I wanted to make was regarding the women's right, which Ms. Pathak has made. And Lordship, the final point I want to make it till 2016, even transfer petitions could not be filed in this court under the regular provisions. We have to approach under 32 or in the other provisions.
Thank you. Yes, sir. What do you have to say?
19618, my lord. In my matter, my lord, no counter, no students of has been filed, my lord. I got a letter circulated on 27th July, my lord, saying therein that I shall be able to file written submission only after hearing with the court. Now I may kindly be allowed to.
What? And what is that SLP?
118, my lord.
Filed by whom?
Filed by whom actually? You are the SLP petitioner.
My lord.
What is the order that you are challenging?
My lord, I am challenging the order on the part by the High Court, my lord. I saw there, my lord, to declare Article 370 a left provision. Second, my lord, declare separate constitution for the J&K wide ab initio.
That is
Now that is, yes, that is.
My lord, that I am seeking
subsumed in-
permission, I am seeking permission to file written submission. In view of my letter, my lord, which I circulated on 27 July.
So we'll come back after.
Yeah,
that.
while,
After
during
hearing-
recess, may I just
going
file
through my
minutes,
law-
my submission so that they are on record, Manoj?
My lord, after going through my written
They are,
submission, my
they are
lord.
longer
Because
than
I have
the
to
main
reply,
subject.
Manoj, I have to reply, put
They
it
are
down. on
longer
paper.
than the
Let
main
them open with,
arguments.
I'm
we'll-
sorry?
You can open your submission.
My lord,
We'll see.
permission
That's what
may
I'm
be
saying,
granted
Manoj, that
to
I
file
will.
my lord
We'll
written
hear you,
submission.
Mr. Sibil. After lunch, we'll
Yes,
hear you.
in the meantime, I should be able to file, Manoj.
They are
because
longer than the main submission.
Once
They are-
again,
they are lots
you
of
have
them.
filed hundreds of documents, I never objected, even my
Well,
first
let me
submission, you never, what is
reflect
all
on
this?
it at lunch. We'll
My
hear
lord,
you at lunch.
written submission may kindly permitted to
Yes,
file,
yeah.
my lord.
Hello, check. Hello.
Sir, we are concluded now. Yes, Mr. Sibal. No, sir.
Sorry.
Thank you. Sorry. Sorry, sir. We have.
Sorry.
Thank you. All right. Thank you. Thank you. Thank you. Selfie arose out. Thank you. Yes, Mr. Sibal.
Yes, please, Your Lordship.
What we have said has been said. What the Chief Justice had to say has been said. We've heard both sides, I think, for 15 days, quite patiently. Maybe, not everybody can be heard ever since it's annualized. Don't try ever to browbeat the court. We'll never try that with you. Either with the chief or with me, anybody you try that. Okay. Thank you.
Yes,
As
thank
you
you.
said, thank you. That's
Yes,
all.
Mr. Sibal.
Next, Mr. Sibal. Next matter.
Yes.
Yes, Mr. Sibal.
You're not appearing before a trial court. You're appearing before the Supreme Court. Yes, yes,
Allow me
Mr.
to
Sibal.
argue, please.
Yes, Mr. Sibal.
No, Malas, at the outset, I wish to state, Malas, that this case has been argued at several levels. And Malas, most of them unsolicited, without reference to the arguments made by us. I don't think anybody on this side challenged the sovereignty of India. Nobody on this side challenged the sovereignty of India. I, Malas, at the outset stated that Jammu and Kashmir is an integral part of India.
They say your first petitioner has said something which are not in sync with.
I'm not concerned with that. If the first petitioner has said something, if he has said it, in what circumstances he says it, is it recorded? You ask him for an affidavit. I have nothing to do with it. There are two.
Mr. Sibal
One second,
appears
hold
for
on.
him.
Let's not take time on that.
For him.
One second. Let's not take time on that. I am not standing for him for what he said if he said it. I am not here.
Mr. Sibal, do we take it that Mr. Lone therefore unconditionally accepts the sovereignty of India and that Jammu and Kashmir is an
He is
integral
a
part
member
of
of Parliament today. He has sworn to the Constitution of India. He is a citizen of India. How can he say otherwise? And if anybody has said it, Malas, I, at my level, deprecate it.
No, look, it
Malas,
is
what's
one
the
thing
point
for
of-
Mr.
let's
Sibal
not-
to deprecate.
Let's not go into an issue.
A litigant before your lordships.
Ask him to file an affidavit, then I have nothing to do with it.
No, but it's your client. You have to ask.
I don't know.
He
You are
must
making
file
an
an
allegation.
affidavit.
I
He
don't
will
know.
not support terrorism.
Right, let them reflect on it.
If you don't mind, take it on the pleadings, ask him to file an affidavit. I may
it is on
not
affidavit.
appear for him. I don't know, Manas. What have I am not to answer what an allegation that is made.
Because Mr. Sibal, when he invokes the jurisdiction of our court under Article 32 of the Constitution, he therefore necessarily abides by and owes allegiance to the Constitution.
And he's a member of the Lok Sabha. He is
How
sworn
does
to the
that matter?
Constitution of India. He's a citizen of India.
One second, Mr. Sibal. But that's one second. That's a submission, Mr. Sibal. But we want to have it from him that he unconditionally accepts that Jammu and Kashmir is an integral part of India, and that he abides by and owes allegiance to the Constitution.
Of course,
And does not
he has sworn to it when he became a member of the Lok Sabha. Manas. He swore to it.
Mr. Sibal, because then when you argue and you accept, as far as sovereignty is concerned, you accept the sovereignty of the,
Of course.
number one, the people of India. Number two, that J&K is integral part of India. When you argue, your client says something outside the court, something different to it, there's contradiction. And probably then he's also accepting there was a issue and a problem which had to be dealt with.
If I start, Manas, recounting.
No, I'm not saying
what
that.
may
So
have
we be
happened,
clear on that.
Manas, it will unnecessarily lead only, Manas, to a media coverage. Let us not go that route. We are arguing a pure constitutional issue. If, Manas, there is a speaker of the BJP who was present there when this allegedly happened. There are some people who asked him to say something which he did not say. Why do you want me to go into all this?
No, please go into it. I have no difficulty. Lord, there is
It
an
is not
affidavit.
part of the record. It has been withdrawn. It has been deleted from the record. It is said in the Yeah, what is all this? It was said in the assembly, the BJP speaker was there, the speaker not of his party, the BJP speaker was there. He was asked to say something which people ask other people to say on the streets of this country. Why do we want to go into this?
No, Lord, we would insist, Lord, you must go in.
Therefore, we accept.
Of course, but unconditionally.
We proceed on the basis that he's willing to file an affidavit before our court saying that, well, he owes allegiance like every other Indian citizen to the Constitution of India, and that Jammu and Kashmir is an integral part of the country.
Another aspect, Lord, I'm sorry for the interruption. Another aspect, the affidavit mentions that in all public speeches of petitioner number 1, he supports separatist elements and other elements. Let him say he does not support secessionism and terrorism. No citizen of this country can have any objection in filing that affidavit.
There's another
I did not support terrorism and
There's
secessionism.
another petitioner, Justice Masoodi. Please allow me to argue.
No,
For Justice Masoodi. You want to take any action against the gentleman, you take action.
Unfair to us.
Please don't derail a pure legal submission.
We'll hear you for Mr. Lone as well. There's no difficulty.
He wants to have
He has come to our court. We are more than duty bound to hear his submissions, and we are in the course of hearing his submissions. All that we want to say is, like everyone else here, because we have had people from across the political spectrum in Jammu and Kashmir who have presented rival viewpoints before us, different perspectives, which is welcome. That's why we are here to resolve those issues. But all of them have come here in one spirit, which is that they abide by the integrity of the...
You cannot be a member of the Lok Sabha and be a member there without abiding by the Constitution and an oath of office that I abide by the Constitution of India. He has to take that oath because he enters the Lok Sabha, as we all do.
That's what.
And there's an affidavit filed there, Malaj. How can that be? But be that as it may, Malaj, I did not know of this fact till this morning. Somebody
asked him to file a short affidavit before us, a one-page affidavit. That's all that is necessary.
Lord, we are given a copy to Mr. Sybil's client. Lord.
We'll give the affidavit. There is no question, Malaj. I would not stand here if he doesn't give it. I would not stand here arguing for him.
So before we close the argument, tomorrow just ask him to file a one-page affidavit. That's all that we require.
Yes, and I would request Mr. Sybil to insist to his client that no citizen would have any objection in saying that I do not support terrorism and separatist activity. Let him say that. Or say that I will not say this. Let it be clear.
What is all this?
Which he is supporting.
What is all this? Well, we will certainly, Malaj.
I'm sure Mr. Sybil will.
So we'll convey this to him and he will file a short affidavit.
Had I known this, I would have myself.
What affidavit?
Anyway,
will you allow me
tomorrow?
2:30. Half an hour is lost just on this.
Mr. Sybil, yes.
It's not just on this, Malad. It is a serious issue.
What is a serious issue? But do you want me to say something that I shouldn't say in court?
Well, he wants his fundamental rights to be enforced in this.
Everybody has fundamental rights in this country.
But you take a
including those who on the streets you vilify.
They are also wrong.
So then that's all right. Then you should apologize for them.
All right. Yes, Mr.
So let me argue the case, please.
They are not
Mr. Solicitor, we have indicated to Mr.
Your Lordship have indicated
now open the argument.
I made a commitment that there will be an affidavit.
Mr. Sybil, you open the argument now.
Yes, please. So, Malaj, this case has been argued at different levels.
Yes.
And Malaj, I was somewhat pained when one counsel argued that we respect the sentiments of the people of Jammu and Kashmir, but you must also respect our sentiments. Now, Malaj, I think that we cannot reduce this case to an emotive majoritarian interpretation of the Constitution of India. Whereas all residents in Jammu and Kashmir are citizens of India. They are as a part of India as anybody else. If historically there is an article of the Constitution that gives them certain rights, Mullahs, they are entitled to defend that as a matter of law.
Yes.
Those rights may be taken away, may not be taken away. Constitutionally or without reference to the Constitution is another matter. But to say that you must respect our sentiments as if they are somebody else itself is creating a kind of chasm that shouldn't be created, especially in court. That's number one. Number two, Malaj, and I adopt Mr. Salve's argument, that we are concerned with the interpretation of 370. read the text, understand the context, and interpret 370. I entirely agree with that. And that's exactly what I'm going to do before your lordships. Number 3, Malaj, if you look at the history of India in that context, Malaj, you will find that Jammu and Kashmir had no links with the rest of India, geographically. No links. No part of the territory of Jammu and Kashmir was linked to the rest of India. And the two principles on the basis of which accession had to take place was contiguity. You have to be contiguous. That's how Malaj, states like Junagadh, Hyderabad, many other states which were within India could never accede to Pakistan because that principle could not be established. So you had to have contiguity, and you had to have population. These were the two principles. And the decision, the third, was to be taken by the ruler. These were the three principles on the basis of which accession took place. Actually, Jammu Kashmir was not contiguous to India.
How do you say that?
Because, Malaj, it is Radcliffe, when he came and he made the award, he gave Gurdaspur to India. That's how we got contiguity. That's part of the Radcliffe Award. Of course, Radcliffe, when he came, knew nothing about India. So you might appreciate, Malaj, what were the forces behind it. And Firozpur was a district connected to Gurdaspur, which had a Muslim majority population. Firozpur was also given to India. That established contiguity. That one historical fact, Malaj, your lordships may know. And it's part of the records, Malaj, of the case. The second grave issue that was confronting India at that point in time was Greater Punjab was Muslim dominated, not the bifurcated Punjab. The majority population was Muslim. If you gave Greater Punjab, or what was Punjab at that time, to Pakistan, their boundary would reach Delhi. Nobody could afford that. And if India got all of Punjab, our boundary would reach Lahore. Neither Pakistan would accept it, nor India would accept it. These are historical, this is a historical background in the context of which the fate of Jammu and Kashmir was to be decided. Note another fact. Jammu and Kashmir had a constitution, a detailed constitution of 1939, which had an administrative structure like any other democratic structure, except that the Praja Sabha was dominated by Dogras. In fact, all the nominees in the Praja Sabha were Dogras. Sheikh Abdullah, who had an egalitarian outlook, was dead against the ruler and therefore was imprisoned. There was a popular movement in Kashmir against Hari Singh. Sheikh Abdullah and Pandit Nehru were of the same bent of mind, because Pandit Nehru also showed utter distaste for the concept of rulership. In fact, it was Sardar Patel who said, we must honor our constitution. Nehru said, no, we shouldn't. We shouldn't give anything, no privy purses to the ruler. That's all a part of record of history. That's why when the invaders came into Jammu and Kashmir, Nehru said, release Sheikh Abdullah first. And he became the interim prime minister. He then was made a member of the Constituent Assembly of India to negotiate the terms of the details of the accession. And remember, the constitution of Jammu and Kashmir, like no other princely state in India, no other, I say, was drafted after 1950. And came into force in 1956, 57. It was completed in 56, came into force in 1957. Only state, only princely state. That's one set of historical facts that your lordships must keep in mind. Second set, even more important. The Indian Independence Act was passed in Parliament in UK on the 18th of July, 1947. Originally, India was to be granted independence in May 1948. The date was preponed to 15th August 47. So after the Indian Independence Act was passed on 18th July, you had 12 plus 17 days to complete the process of signing 562, if at all, instruments of accession. On the 25th of July, note this date, that's why I said I needed to put it on record, because your lordships don't allow me. Because my learned friend Miller's filed 18 pages of written submissions and then 250 Millers. I tried to file 5 pages and I was told I cannot, but that doesn't matter. This is all part of the record I wanted to place, but it doesn't matter. I think your lordships should take it on record, but I leave it to your lordships. Anyway.
Is it the only thing that you want to file is now this 5-page submission?
No, that was originally which your lordship denied me at that time. But I, because he has made some list of dates.
What do you want to file now?
Nothing, just basically I have to meet the arguments.
Fair enough, but so long as what you're filing is not much more than what everybody has so far filed.
No, Manoj, why would
you don't want to be confronted with a 300-page document.
Manoj, your lordships, I will not waste a minute of your lordship's time, Manoj.
So how big is it, and what is it that you want to file?
38? 38 pages. There's nothing much.
All right. File the 38 pages, no difficulty.
Simple, we've even taken note of your earlier 15 pages. But if we had permitted you to file, the whole sequence would have...
I'm not complaining.
Everyone else would have then followed. That's
the last one to complain. I never raised the issue. But when I was told that I can't file...
No, Mr. Sibal, it was not meant for you. It was meant for everybody.
I know that.
So
but everybody filed. The problem is everybody filed. But neither... there's too little time.
We took down the need of having to record in writing
That's
what
correct, that's-
we have argued, but now we've taken.
It's all
it
right,
as a
no problem. So, Manas, the say, what? His list of dates, not mine. No, no, no. We have already added, your list of dates I've made a blue mark. Is you have had these green and yellow and that. I've just added a blue mark to your list of dates. That's all. Not my list
So
of dates.
their list of dates, as I recall, was about 110 pages.
10 pages. I've just added 5 pages to that, Manas, to give some correct date.
So the 115 includes the earlier 110.
That's right, that's right.
And 5 which you have added. Fair enough. That we don't mind. There's no difficulty. And you have followed the same format, track
that
changes.
your lordships are not.
We know what you have added at the end.
Exactly. It's in blue, Manas.
So long as otherwise, it becomes impossible when we are just to sit down and
I
dictate a
told them,
judgment.
Manas, we mustn't burden your lordships, and therefore we did it that. Anyway, so let's, Manas, move on. So, Manas, on 25th.
So, just a second. You're filing, therefore, your list of dates, which
Yeah.
are 150
And my written
pages.
submissions, Manas, in response.
The written submissions are 38 pages.
Yes, yes, yes.
So all that you are now filing.
There's an appendix,
one second.
appendix to it, Manas.
That total 67 pages. Submissions are 1 to 38, annexures are 39 to 67.
That's only appendix, Manas. That's an appendix data, Manas. That's all, nothing more than that.
What is the nature of the
Data,
annexure?
for example, he said reservation didn't apply to Jammu Kashmir. So I'm saying it applies. This is the article. So these kind of things, Manas.
All right.
There, for example, no education. Actually, education in Jammu Kashmir is free up to university. Free education till university. In the constitution itself. Manas, I mean, these are facts which should have been stated by the other side. They say there's no official language. There was an official language.
You can file it because
Thank
we now, it's 5 pages, basically 5 pages of list of dates
Yes.
added on.
Yes.
And your submissions about 38 pages. The annexure is to explain what, according to you, has been made available or what is.
That's all, nothing more. And I want.
But in the same vein that you said, don't take into account what they have said on the more, should we say, developmental aspects. We shouldn't take into account what you have said also on what is available.
Exactly, Manas.
To answer the core constitutional issue.
Exactly. That's why I never went into that.
So, Sibyl, when you say 5 pages on the lighter side, my court, at least when I used to say 5 pages, if somebody handed over 10 pages, I has to remove the last 5 pages and
Right.
confine it to the first 5 pages.
Now, let's note another thing. On 25th of July, 1947, the Chamber of Princes met. This was. So, Manas, in the Chamber of Princes, Sardar Patel said, we will only have with us that the union, communications, external affairs, and defense. You are autonomous for the rest. 25th of July. 25th of July. That's also part of the record that I've given you. Mountbatten said it on 5th of July, he had said it also. So, Manas, therefore, and that was the understanding with the princes. It will be a federal structure, communications, foreign affairs and defense will be the union, and the states will be autonomous. That's one part. The other part was, Manas, there were some princely states, Manas, one of them, the only property it had was a well. He was a prince of that well, Manas. He had no means of livelihood. They naturally, such small states had to join larger princely states. Kathiawar, Saurashtra. Saurashtra had incorporated 220 princely states within it. The whole process of 17 days was an entirely asymmetric process. Idea was to persuade all of them to please sign instruments of accession. Epsu was one of them. Faridkot, Pesu, all those. That was happening, Mullahs, with Sardar Patel and VP Menon and Mountbatten, who had personal relations with all the princes, which neither Sardar Patel had nor VP Menon had. Because then the Governor General Mountbatten was actually served in India for a long period of time, and each of these princely states had a resident. And they would be told that you only should spend 10% of your revenue of the state on yourself, the rest you should spend on the public, but most of them spend 80% on themselves. But ultimately, they all exceeded. They all signed instrument of accession by 15th of August. With a standstill agreement and nothing more. Some of them who merged into larger administrative units didn't have to do that, because then they were represented by the larger administrative units. So my learned friend, the solicitor, is right that many of them, princes, did not merge because they were merged with other larger administrative units. So it was an entirely asymmetric way of actually getting them all together in 17 days. It was a Herculean task. Ultimately, who stood out? Hyderabad, Junagadh, Kashmir, and Travancore. In fact, the first ruler to revolt was Travancore. Yeah, because of the advice of the Dewan Mullahs, who ultimately got attacked and was in hospital, and then they signed the instrument of accession. But that's just the Mullahs. I know, I don't want to take it. And Mullahs, now you were left with Junagadh, you were left with Hyderabad and Kashmir. And as far as Kashmir was concerned, your Lordship knows, the instrument of accession was signed subject to certain conditions. In many of the instruments of accession that were signed by with other princes had a provision that there can be a supplementary instrument of accession, but there cannot be unless I give consent. That is, the ruler gave consent. So some of them had supplementary, but this didn't happen in Jammu and Kashmir. The point that I'm making is, Mullahs, Jammu and Kashmir was the only state in India where a special dispensation was made for reasons which were domestic and reasons that were international. Which is why this whole argument that there must be uniformity is completely bereft of the historical context. Now, principle was contiguity and population. Junagadh acceded to Pakistan. Acceded to Pakistan. Somnath temple was in Junagadh, very dear to all of us. So, Mullahs, having acceded to Pakistan, India wanted to invade and take over Junagadh. Mountbatten said, you can't do it. He has acceded to Pakistan. This is foreign territory for you. So ultimately, Mullahs, infiltrators were sent. And they took over and there was no resistance. Then negotiations took place and Pakistan agreed to a plebiscite, a referendum. Knowing full well that such a referendum would happen in Kashmir also then. The same thing happened in Hyderabad. The ruler was Muslim. The people wanted to join India. But he did not join Pakistan. He wanted to be independent. He didn't accede to Pakistan. And there was a general this happens nowadays also. There was a freelancer who promised the ruler of Hyderabad that I will get you arms, you give me so much money. So they piled up a lot of arms to resist any invasion ultimately, Malaj, that man, Mr. Cotton, left him and the invasion took place and be occupied. Now you're left with Jammu and Kashmir. Jammu and Kashmir, the population was Hindu, Muslim majority, and the ruler was Dogra. It is in this historical context that you must view what happened in Jammu and Kashmir was only to ensure that Jammu and Kashmir becomes an integral part of India. There can be no question about it. I'll come to that. Yes, I'll come to that. There can be no plebiscite in Jammu and Kashmir. That is our position. We stand with India. Now, Manas, having signed the instrument of accession by 15th of August and some of them standstill agreements, the question then was they had to merge because none of them had any administrative units in place. You had to have local self-government, and your lordship knows at that point in time, we wanted India to be a democratic nation. So then Sardar Patel and Menon persuaded all of them to please have merger agreements so that we can treat you in the same way as other provinces. So all of them signed merger agreements, not Jammu and Kashmir. Nor was Jammu and Kashmir asked to sign a merger agreement. Never.
How many merger agreements were there actually?
I'll give you the number, Manas. I think we have them. No, much less. Much less. I will give your lordship the number.
Because everybody who signed an instrument of accession didn't necessarily sign a merger, right?
No. Because what happened was, Manas, many of them
had formed unions with existing states like Kathiawar or Saurashtra.
That's right.
Pepsu.
That's right. You'll have that. Well, that's not an issue. So, Manas, that didn't happen in Jammu and Kashmir. So when the infiltrators came, and he couldn't defend himself, and he went away from Srinagar, he ran away from Srinagar. And we helped him, Manas, by going there. The issue arose, we had no communication systems in place. No communication system in place, and we didn't know the topography. Our army, because we had never been there. The army represented that if you want to deal with the infiltrator, the source of it is Pakistan. So we'll have to target Pakistan, to which Mountbatten said that will declare war. If you do that, it will be war. You cannot be allowed to do that. So we were not allowed to do that. So the result was that in that situation, kindly remember, referendum is not the only place that we're talking about in Jammu Kashmir. There should be no referendum. There can't be a referendum in any case. But referendum happened in the northwest provinces. We had the Congress government in the northwest frontier province. A referendum happened there and they went to Pakistan. Referendum happened in Junagadh. So it is not as if this was alien to the concept of how people express their wills. But in our case, what happened was the government of India said, let the Constituent Assembly, namely the people of Jammu and Kashmir, represented in the Constituent Assembly, express the will of the people. That's how 370 came in. There was no other way to express the will of the people, certainly not through a referendum. Nobody wanted it. especially after the first year, because in 1953, Sheikh Abdullah was arrested by Nehru because he raised the slogan that we want to be autonomous. Sheikh Abdullah was arrested by Nehru himself. Nobody wanted a referendum. Nobody would have allowed a referendum. But the way out was, in that context, draft a provision in 370 by which the will of the people of Jammu and Kashmir can be expressed through the Constituent Assembly. That's the historical lay of the land, Mullah, in the context of which you have to read Article 370 of the Constitution. Now, Mullah, let me disabuse your lordships of some of the myths that have been portrayed here. Number one, that Parliament has plenary powers under 370. Just the contrary. The power of Parliament to make laws is limited by 370. Nobody's read it. Just look at 370, madam, with me. Please read 370.
I don't think there are limitations on Parliament's lawmaking power because...
No, not that.
Yeah.
Well, that I'm not saying that. Well, I'm saying something different. Just read 370 with me. I'll read it with you. Yes. Notwithstanding anything in this Constitution, the provisions of 238 shall not apply, and the power of Parliament to make laws for the said state shall be limited.
What are you reading? Which?
Article 370.
270.
It is a limitation on the Parliament to make laws. Yes, 1B. To matters in the union list, to matters in the state list, in the concurrent list. It stares you in the face, and you're talking about plenary power. Where is that plenary power? If you want to pass any law, or if you want to extend the provisions of the Constitution of India, forget about 371 B1 and 2. Look at D. If you want to extend the Constitution of India in respect of matters which are in the instrument of accession, outside of those matters, you have to consult, otherwise you have to take concurrence. And how does the President of India act? On the inner advice of the Council of Ministers. The President is not acting in his individual capacity. It is the Council of Ministers which will decide, not Parliament. The Governor acts on the aid and advice of the Council of Ministers. It is the Council of Ministers at the other end which will decide, not the legislature. It was to ensure that there is slow integration of Jammu and Kashmir into India through a process that is easy, through a process that will allow the executives communicating with each other to make sure that the Constitution of India, as applied to the Constitution of Jammu and Kashmir is put into effect, which is why the CO in 52, in 54, that's the background. Once we decided on the list that this is the entry in the list on which a law can be made, and two executives agreed on it, a law is made and it will be applied. That's the procedure, Malaj. Nothing to do with how they have interpreted the Constitution. And that's how it happened all the time. Which is why, if your lordships will remember at the outset, I said, this is an exercise of executive power. It is not even exercise of legislative power. Far be it some quasi, some ancillary constituent power. Doesn't exist. Millers, I am asked this one question for which, Millers, if you have an answer, Millers, I certainly don't have an answer. Millers, throughout, Gopalaswamy Iyengar, who was part of the drafting committee and who introduced the bill, understood 370 as we have argued before your lordships. Exactly that. From 1950 to 5th of August 2018, no member of parliament, no member of parliament, no individual in the public space said otherwise. Nobody said it. Every interpretation of the Constitution as reflected in the debates in Legislative Assembly and in Parliament interpreted the Constitution as Iyengar interpreted it and as we have argued before your lordships. There has never been a dissent. When the government of India files an affidavit in this court, it's the same thing, except they say that now through this process, we have substituted the Constituent Assembly with the Legislative Assembly. They have understood 370 in the same way. Now in the argument, not part of their affidavit, not part of their pleadings, they say, no, there is some plenary power. Your lordships are not sitting here in an advisory capacity to tell them as to what 370 means. We are, Millers, testing the action of the union. We are not having some academic exercise of the interpretation of 370. We just to test CO 272 and 273. Whether it was rightly done or wrongly done. Maybe rightly done, maybe wrongly done, that your lordships will decide. But it has nothing to do with any plenary power, nor is it the case of the union. Now, let's accept their argument. Let's see, test it, Millers, how it would be. They say, this is a plenary power. Forget the proviso because the Constituent Assembly is dead. There is no Constituent Assembly now. There is a Constitution of Jammu and Kashmir which is in place. And the argument is, now that it is dead, I can exercise that power and abrogate it. That's always been the position. So what it means is, Millers, that the Constituent Assembly and the people of Jammu and Kashmir signed their death warrant on the day the Constitution was made and the Constituent Assembly was dissolved. On the next day, 370 could have been abrogated. Instead of 5th of August 2018, 19, they could have abrogated the next day. So they were signing the death warrant that while we are there, you can't do anything about it. But the moment we have drafted the Constitution of Jammu and Kashmir, then you can tomorrow just take away. Just abrogate 370. What is, can any constitutional court can never interpret 370 in this fashion? Can anybody even think about it, Millers? That a Constituent Assembly drafting the Constitution of Jammu and Kashmir, saying that we are an integral part of India, taking note of 370 in the manner in which it is to be integrated into India, will say to themselves that the day we are not in place, it will be abrogated because there's a plenary power superior in 370, which is not there in 370, but because we say so, and which is not even part of the counter affidavit of this. This is not even the case of the union. What are we? Wait, this is not some I mean, this is not even. You look at it textually, you look at it contextually. There is no other conclusion you can come to. Now, your lordship asked me several times and asked others also, what's the way out? That's not for your lordships to decide. Your lordships are not here to tell them what the way out is, or for us to tell them what the way out is. It's a political process. The way out is a political process. Or some other process, that's for them to decide. But the way out is not this, that you do something consistent with the interpretation of 370 and you argue exactly something else, which has nothing to do with your own counter affidavit, and that's the union. How can they be allowed to do that, Manoj? What does concurrence mean? It means consent, as your lordship has been saying. If it requires the consent of the governor of the council, governor acting on the aid and advice of the council of ministers, where is that plenary power that we are talking about and reading in 370? And 370 sub-article 2 says that if an order is made, Malaks, between 1950 and 1951, when the Constituent Assembly was in place, the Constituent Assembly can reject it.
Sibyl, why does the proviso to clause 3 use the expression recommendation when two other provisions in the same article use the expression concurrence?
Yes, I'll give your lordship that.
B2 uses the expression concurrence, and the second proviso to D uses the expression concurrence.
Absolutely. In other words, Malak, when it comes to applying the Constitution of India to Jammu and Kashmir in respect of in matters which are not with reference to the lists, Malak, you need the concurrence of the state government acting on the aid and advice of the Council of Ministers. At least, Malak, with that there is no plenary power of Parliament. Concurrence means I can say no. Means an executive can say no to what is proposed. Now, if you read 370, and I just answer my Lord's question, if you read 370, the president's still notification cannot be initiated. Because the expression in the proviso to 370 are two expressions, necessary and before. The timing is set before the president issues a notification, a recommendation has to come, and that is necessary. And the order in which is that the recommendation will come, then you would pass an order. You can't reverse that process on a plain language, on a textual reading, which I said, Mullahs, I accept what Mr. Salve said. Read the text and give the answer.
Mr. Sibyl, is it not conceivable? I mean, I'm just thinking aloud.
Yes, sure.
That so long as Article 370 operated, it provided modalities for the application of the lists, the entries in the three lists, consultation in one case and concurrence in the other.
Right.
So long as Article 370 operated, it provided for the application of the other provisions of the Constitution, subject again
to the same process.
Same formula, consultation and concurrence.
Absolutely.
You probably rightly said that the object was to bring about a slow integration.
That's correct, which I've been saying.
In achieving that slow integration, the Constitution framers provided for consultation, this whole formula of consultation and concurrence.
Absolutely.
Checks and balances at two levels of government, the union government and the government of the state. But significantly, the Constitution doesn't tell us what would happen after the Constitution of Jammu and Kashmir would be framed. it contains no express provision that that constitution would then be embodied or incorporated in the Indian constitution. Because the Indian constitution, by all indicators, we've seen several indicators, was always to reign supreme. So when it came to abrogation, it left in 1950 the point of abrogation to the exercise of wise statesmanship. You just said a short while ago, why didn't they do it in 1950?
No, not a question to do it. They had the power to do it. I'm not on that.
You're right.
Yeah.
I mean, you're right. Why did they not do it? They had the power to do it. If they had the power to do it,
Because they never understood 370 in this fashion.
no, there's an alternate hypothesis. It was always presumed that allow 370 to work out. There should be an eventual process of integration. Let that integration take place over a period of time, during which you will have this twofold procedural check of consultation and concurrence. At what point of time the integration is deemed to be complete, or that Jammu and Kashmir is ripe for an integration with the rest of India in the full and true sense of the term, was not hedged in by the constitution.
Mullahs, I'm sorry, with the greatest
Is that,
respect.
is that not a possible?
No, it's not. It's not, Mullahs, on a plain reading of 370.
Because there are very significant silences in Article 370.
Mullahs, you don't need expression of interest in this fashion for the simple reason that that 373 itself gives you a clue as to what was the reason.
There are
behind
not sufficient silences in Article 370 to lead to the conclusion that the framers, both when they were on that side in the state of Jammu and Kashmir and on this side in the Union of India, left it to wise acts of statesmanship in 1950.
I hope on both sides, Mullahs.
Yes, of course.
This was a unilateral act, Mullahs. This was not a wise act. It was a unilateral act.
Just one, taking on what Chief Justice just said.
Yes.
It's quite apparent at that time what was either happening with the rulers and integration into India, because that was the objective. And it was all a political move at that time. There were different views expressed even with regard to J&K. If one looks at the wording of the articles, the argument of the other side was it was deliberately left very flexible and to some extent contradictory.
Yes. Mullahs, I don't see the flexibility here, Mullahs, neither I see the contradiction. Just read 3 with me, Mullahs. If you find, Mullahs, that there's a silence there about what would happen, Mullahs, certainly.
And except for the provision for permanent residence, Section 6, which finds its mirror image in Article 35A, every other provision was really a mirror image of the Indian Constitution. So what is that an indicator of?
That's an indicator of the fact that
whatever is happening there is really the incorporation or the adoption of what is happening in the
I can only say this to your lordship. I can only say
of the Union of India.
I can only say this to your lordship, Mullahs. Either we interpret 370 sub-article 3 in its text and context, or we find something that's not there. And as a matter of constitutional law, Mullahs, you have to interpret the Constitution, not find a silence in the Constitution to interpret something that is expressed. Let's just read it, Mullahs. Notwithstanding anything in the foregoing provisions of this article, the President may, now who is the President? Acting on the aid and advice of Council of Ministers, may by public notification declare that this article shall cease to be operative, or shall be operative only with such exceptions and modifications and from such date as he may specify. Now just pause here. Supposing, Mullahs, he was not to abrogate, he was only to modify or apply with exceptions. Is that also unilateral power? Forget about abrogation for the moment. We have to interpret constitutional provisions as we read them, Mullahs, not as we find some element of silence which is not there. provided that the recommendation of the Constitution, this is a proviso, Manas. That the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary. That means to start the initiating of the process, that recommendation is necessary. And before the president issues the notification. It's a double emphasis of how that power can be exercised, not by parliament, but on the aid and advice of the government. So, Manas,
we'll of course have to then, to accept your argument, we will have to read a further condition in the proviso that the recommendation of the Constituent Assembly has to be in the same terms of the action which is proposed to be taken by the President. Namely, either that if you are abrogating, there must be a recommendation that yes, abrogate.
Yes.
Or if you are making 370 applicable subject to such changes,
yes, same thing.
Then the recommendation must be also along the same.
Yes, absolutely.
But that's not there in the proviso, isn't it?
It is, Manas, it is, before any of this. Kindly see, provided that the recommendation of the referred to in clause 2 shall be necessary.
Look, this is a core argument on which you have taken one stand, the other side is taken another stand. We'll have to.
No, all I'm saying, Manas, at the moment is, Manas.
What their stand is that proviso will not evaporate and write off the third clause of Article 370 after the Constituent Assembly as.
Manas, at least it's
That
so far.
Your stand is to the contrary.
So far, Manas, I can only go by precedent. So far, the proviso has never been interpreted in the fashion that they are seeking to interpret. In any judgment of the Supreme Court since 1950.
That occasion never arose, probably.
That's not the way they acted. Manas, kindly please appreciate what they've done.
Therefore, according to you then, if the proviso cannot be applied because the Constituent Assembly has come to an end.
No, Manas, with respect I say, that's not the point.
Because the proviso says the Constituent Assembly referred to in clause 2.
Correct.
So it is only one Constituent Assembly which was formed for the purpose of the framing of the Constitution of J&K.
Correct.
Even if you have another Constituent Assembly in J&K, you can never have that Constituent Assembly which was for forming the Constitution.
No, Manas, let me answer.
Therefore, the proviso cannot apply at all.
Let me answer it.
In your submission?
Yes. My answer is the following, Manas. When the Constitution of India was framed in 26th of January 1950, there was no Constituent Assembly and there was no Legislative Assembly. So what did Manas, the Constitution makers, provide for in the proviso? They envisaged that there would be a Constituent Assembly. They envisaged that there would be a legislature. If there was a Constituent Assembly which would abrogate 370, there would be no Jammu and Kashmir legislation. Constitution, there would be no Jammu and Kashmir Constitution. Because that's abrogation. Constituent Assembly would recommend abrogation. At that point in time, those who drafted the Constitution were not aware as to what was going to happen. That's why. Sorry. I'm sorry.
370 in the slide, there are two arguments. One, obviously, with reference that the proviso will not be controlling the main part of 3. That's a core dispute between them.
That's right.
Provision will not be applicable is contradiction in terms.
Now, Manas, let's put it differently. Manas, this whole process was the political process. That's what Salve argued, council argued. This is a political compromise. So you pull the plug anytime you want to pull the plug. At least 370 doesn't allow you to do that, but assume that's the case. If it's a political compromise, there will be a political solution. Why are lordships finding some constitutional solution that doesn't fit into this? That's not what your law, Manas. You have to, please look at it this way, Manas. If the process was political, the solution has to be political. Now, how that solution comes about is not neither for your lordships, not for us to suggest. This is something that they have to do in collaboration.
The initial part was political, now it has to be constitutional.
No, Malad, if that is so, Malad, if now it's constitutional, then that means that the
While
Constituent
keeping in
Assembly,
mind, while
just look at
keeping
it
in
this
mind,
way.
the fact that the intent behind the article was temporary and transitory.
But that I'll come to a little later, but Malad, the answer to the question is that the Constituent Assembly was framing the Constitution of Jammu and Kashmir, knew that after that task was over, it would end, and was signing a death warrant under 370 sub-article 3 that now you can abrogate the Constitution. Well, that can't, I'm sorry, Malad, on a plain reading of 370, I have the greatest respect for your lordship.
Therefore, the sequitur of your submission on the proviso to clause 3 is that once the Constituent Assembly has formulated the Constitution of J&K, which has been adopted,
yes,
the proviso ceases to have any existence.
Yes, and 370 ceases to have effect.
Therefore, 370.
370 ceases to have effect. 3 has ceases to have effect.
Sorry, 370 or
sub-article 3 ceases to have.
Therefore, 370
Yes,
bracket 3 ceases to have effect.
Yes.
In which case, 370 by itself, apart from 370 clause 3, assumes a permanent character.
It's permanent in the sense that, well, what is left of this autonomy that we are talking about? If the argument is it is just a shell, what is it that you are trying to do? What is the argument today, Malad? I've heard it, Malad, several times over. What is left is only a shell. Everything is already there.
That there's a contradiction in their argument.
Well, I'm only saying, Malad, sir.
Just one.
Yeah.
There's a contradiction in the argument. They said that main substantial part of the Constitution, including 356, is now fully applicable. But what was the main stumbling block was section 6 and 35.
Because as far as 35 is concerned, that's a separate issue.
No, I'm not interpreting. Complete adoption of the Indian Constitution in toto, in completely, as in case of other states.
Strike down 35A. Well, I don't understand where we are getting here. If this is the only stumbling block, you strike down 35A.
That's the judicial way.
No, that can't be politically done in any case. Because there can be reasonable restrictions and there can be classifications in terms of Article 14. It has happened in Uttarakhand, it has happened in Himachal, it has happened in other states, Malaj. It can't happen in Kashmir. Malaj, it is happening in Assam. You are fixing a date to people who came into Assam.
We come to that a little later.
I'm only trying to indicate, show the mirror to myself that if it happens in Kashmir.
There's actually, I feel, the two spectrums which have to be decided.
Yeah.
When you use the word temporary, whether it is actually temporary in the sense they understand it, or it is temporary in the sense you understand it, that it was with the context of the Constituent Assembly, one. Number two, how you understand subclause 3 is that once the Constituent Assembly dissolves itself, 370 in the form it exists according to you is frozen in time for all times to come. Correct? This is what your argument is.
No, 370 sub-article 3, Malas. The rest of it is still remaining.
Yes, I'm saying 370, the remaining part is frozen as period of time because of the historical perspective.
No, not remaining, Malas. You can continue to integrate. 3 is frozen.
3 goes to the remaining part subsidy.
Yeah, absolutely.
They say no, 373 is not limited to that stage because of the manner COs have been issued and can extinguish themselves.
That COs have been issued not in under 3.
Then comes the methodology, whether they could have done it or not.
Well, the COs have not been issued under 3. This is the problem, Maharaj. These COs can continue to be issued. All of them are under 1. So, and Maharaj, I'm sorry to say this, when you talk of temporary provisions, it is not a temporary provision.
Ultimately, therefore, it will boil down to this, that there is in our Constitution, if we accept your submission, there is in our Constitution a provision to which even the amending power, which is available in respect of the rest of the Constitution, is unavailable.
It's unavailable because it's been amended. 368 has been amended with a proviso.
And there is, in that sense, a provision of the Constitution which lies even above the basic structure of the Constitution.
No, my lords, I mean, why do your
Because you
lordship say
cannot,
it is?
370 you can't amend also.
I'm sorry.
You can't amend 370 also.
It's not
To
a.
amend 370, you have to take the route of 368, and 368 takes you back to 371 by the proviso. Therefore, we would be then really accepting a situation. We're not saying it's unstateable. We're testing the proposition. Is there a part of the Constitution? The only restriction we have found so far in our jurisprudence on the power of altering the Constitution is a basic feature doctrine. We are now going to add one more, which is that Article 370 lay even beyond Article 368,
No,
and much beyond the basic structure doctrine, because you can't touch Article 370. It assumes a character of permanence.
Well, this is getting
Isn't
more
that-
interesting. This is even getting more interesting. Well, let me now ask myself a question. Supposing I were to file a petition tomorrow in this court that the proviso to 368 is unconstitutional. 368 too. Supposing I were to file the petition, and what my lord is saying is upheld, is right, that how can you do that? Strike down the proviso to 368 and amend it under 368. There are hundreds of ways of doing the same thing, Manoj, but we are testing the proposition in the context of what they have done.
The postulate that in the exercise of judicial review,
but your lordships are putting to me.
We must take the proviso as a given.
But I am saying, yes, Manoj, it's your lordships who are saying there's something silent in it, which I don't see, Manoj. I don't see the silence in that proviso where the perpetuity of a presidential notification can be issued at any time, even after Manoj, even.
Because the two plain consequences of your submission are, first, once 370 clause 3 goes out of operation for all intents and purposes, 371 and 2 have a permanent character in the Constitution.
2 is not there, Manoj. 2 is not there.
Right, 2 is, of course, yes, after the Constitution. 371 has a permanent character in the Constitution. Second, you cannot amend 370 using the 368 power because of the restraint which is imposed by the proviso, which again takes you back to 370. Therefore, even the power to amend 370 is within the fold of 370 and not 368.
Let me answer that also straight away, Manoj.
So we are carving out really a provision of the Constitution which lies even higher than the basic features doctrine.
No, Manoj. That your lordship should not say, Manoj, because that's not yet tested. That your lordship should not say, that's not tested yet, whether it's higher than the basic feature of the Constitution or not, Manoj. But kindly see, this was added in the 1954 order, Manoj. The proviso to 368(2) was brought in by the order, as well as, Manoj, the proviso to Article 3 in 1954. Who brought it, Manoj? The government of India. State of Jammu Kashmir did not. They gave its consent to it. Why did they do it? Because they did not want 370 to be tampered with. I'm not saying this, Manoj. I am talking of the intent of the government of India. And the proviso was added both to 3 and 368. Not my intent. And your lordships are now saying, what is the intent of the government of India? It was made clear that even under 368, you can't do this. Government is a continuum. Kindly, Millers, appreciate that. It is not something that was done by Jammu Kashmir on their own. I understand, Millers, and there we go into the sentiment argument, the emotive argument. The argument that Mr. Dwivedi made, with respect, that we appreciate the sentiments of people of Jammu and Kashmir, but there are sentiments in India. Whereas with the greatest respect, I humbly pray that we are dealing with the Constitution. Whereas it's a sentimental thing. I also have sentiments with a lot of things. But when we come to court, we discard do away with what our heart, the nature of our heartbeat, and come to brass tacks rather than interpret the Constitution. You can pepper it with emotive instincts, but you can't get away from the plain language. And my respectful summation to your lordships is a political process must have a political solution. And as I said, what is left of 370? There is no residuary power with the, we talk about residuary. What is the residuary power? There's no residuary power with the state. When did the state ever exercise residuary power? So for all intents and purposes, it is fully integrated.
In other words, according to you, there is no solution to Kashmir within the constitution. Devise a solution outside the constitution.
Now your lordships are putting this to me.
Ultimately, that's
not what I've argued.
That's the hypothesis, that the solution has to be political outside the constitution.
It is a problem looking for a solution, and your lordships don't have to provide that solution, is what I'm saying.
All solutions have to be within the framework of a constitution.
It is within the framework, mothers. It is within the, who says it's not within the framework? Well, isn't 370 a classic form of federalism? Unlinked to the federalism that we practice? It's a classic form of federalism. There's nothing unconstitutional about it.
There can be a lot of arguments on the other side. Let's not go into all that, whether.
No, I'm just saying.
I'm
saying, Millets, it is not unheard of. It is not something that is so utterly unthinkable that a state can have a certain special status.
If you go by Dr. Ambedkar's adoption speech, it's quite clear that he wanted a unitary form, primarily unitary form with certain federal features.
It is unitary, Millets. Who says it is not unitary?
Very clear, and there's historical reasons. And let's not go into the
Ambedkar said an also very important thing. Way Jammu and Kashmir. He said that say something just come to my mind, but I've skipped. No, that's not what he said. That equality is in your mind. The equality, people, all people in this country are equal. Some are not considered equal. That's all. That applies not just to Jammu and Kashmir, that applies to a lot of places in India. So let's not go that route. Well, just because it's a union doesn't mean we are not federal. We are a quasi-federation is what we are. And that's what Ambedkar said, that we're a quasi-federation. But man, it's quite apart from that. That's how all members of parliament since 1950 have understood it. Well, why are we? That's not their case. We are trying to find a solution, which is not the case of the Union of India.
Civil, Dr. Ambedkar in his speech, both speeches, 4th of November 1948, as well as 25th of November 1949, he has distinguished the American Federation with our federal structure, and he has specifically stated that in America, there is a citizenship of the federation as well as the state citizenship, and it permits two constitutions, the state constitution as well as the federal constitution.
Correct.
But in India, we have adopted a single constitution and single citizenship.
Absolutely, right, Manoj, but kindly look at it this way. It is this Constituent Assembly that approved 370, of which Ambedkar ji was a part.
So therefore, the question will be whether it was a temporary measure.
No, this is what the Constituent Assembly said. This is what Manoj, the cabinet said. This is what the government said. This is what the government has been interpreting 370. This is what they have done, Manoj, in the light of the interpretation of 370, as we have placed it before your lordships. What is 272? To replace the Constituent Assembly with the Legislative Assembly. That is trying to implement the proviso, no? They've used the proviso. Now they are arguing just to the contrary. How can your lordships even allow them to do that? We are testing, Manoj. We are testing the process. We are not testing the power. We are testing the process. And the process adopted by them is the 370 sub-article 3 process. They have substituted Constituent Assembly to Legislative Assembly. Then they have imposed 356 and Parliament has become the Legislative Assembly and given consent to itself. plenary power or any silence in 370 which allows them to do what they wanted to do. That's not their case. So we are now adjudicating a case which they have not pleaded before your lordships. If some private citizen were to do that, would your lordship ever allow it?
So, Mr. Sibal, you are saying 373 doesn't exist practically. Correct? That's your argument. Their argument is 373 exists and we've taken that.
No, they
Whether
say
the
370.
process- That's the second part. Whether the process applied by them under 373, if it exists, is the proper process as per 373 or not, is the second limb of the.
But I'm saying something else to your lordships. They proceed on the basis that 370 exists.
Correct.
Therefore, they are not saying that 370 doesn't exist after the Constituent Assembly was drafted and nothing else happened and there's no Constituent Assembly. It's not their case. We are now adjudicating upon a case which is not the case of the Union of India before your lordships.
Many things have been said, Mr. Sibal, from both sides, which are really not, in our view, prima facie germane to the main issue is this of 370, as you say, one side of the argument that with the Constituent Assembly going away, 373 really did not subsist, only 371 survives. Their view is that 373 subsists and that's the route we have adopted. Second limb arises if 373 exists and the route they've adopted, what's the correct route, permissible or not?
But that's what I'm arguing. When I opened, I only argued on the route. If your lordships will remember, I never went into any political argument, any historical context.
So that is your argument that
I never talked about lack of sovereignty. I never talked about federalism. I never talked of any of that. I said this is the process they have adopted and this process is unconstitutional.
I remember you also said that it's not for us to, or for you, or to suggest what is the alternative.
Exactly.
Then when an alternative route is followed, it will be tested in its own way. But
Correct.
this is the route they have adopted.
And
they have
that,
not taken a 368 route. They have
That's
taken
correct.
a 373 route.
So the first question that your lordships have to answer is 272 valid or not? And
that we'll have to decide.
Yes, and that can't be decided. That can't be decided because that they have followed the route of 370 proviso, Malad. It is their case.
Yes, yes.
So the problem there with the argument is that 370 can't be decided in the context of the argument now raised. That after the Constituent Assembly is not there, we can do what we like. But that's not what their case before the court is. Their case is that they have applied the proviso and substituted Constituent Assembly for Legislative Assembly.
That's what the CO says.
That's right. So you have to test only that, which is what I argued. I didn't argue anything else.
We are not asking you to argue beyond it.
No, they have forced me to argue beyond it. They have forced me to argue beyond it. But let me go back
Even
a little.
assuming that they have followed the route of the proviso to 373, I don't think we can prevent them from sustaining the exercise of power on the ground that even independent of that we are entitled to.
That's not in their counter. I'm sorry, Malad, that's not their case. I'm sorry, you read your counter. It's a sweet. Me as to what they say.
They meant 367.
No, Malad, in exercise of the powers under clause 1 of 370.
Absolutely.
So, Malad, they are saying that, and then they say the proviso.
That was for incorporating the proviso.
But I'm only saying that they are.
Sorry, 367 to the, that was for amendment to the 368.
That's what I'm
But
saying.
ultimately then they invoke the power under 370 clause 3.
With the proviso, Malad.
Yes, with the proviso.
But that's all I am saying,
the
Malad. I'm saying nothing more than that. That's the
We have
problem.
understood your argument on that.
Yeah,
We have
I'm
understood.
just saying,
In
Malad.
fact, we had put that question to the Attorney General also.
You also given the answer, Malad. This is a sui generis provision of the Constitution, must be interpreted in its own terms. That's all that I'm saying, Malad. And
Well, I
kindly
think
counter.
this part, I think we've conceptualized, we've put our doubts to you, you've conceptualized your
Giving
answer
life
as
to
well.
373 through Article 367. That's their counter. That's all that we are testing, Malad. Okay, so Malad, that's done. That's done, Malad. I'm done with that. Now, Malad, kindly go back to, no, now kindly go back to the list of dates, and just orally, Malad, I'll mention to your lordships. 20th of June, in 2018, well, that's 19th of June, BJP withdrew support. 20th of June, Governor Amarnath puts the assembly in suspended animation.
Now, the latter part, now you are going into the.
I'm going to test 356.
356.
356. Right. And the dissolution of the assembly on 19th of December, on 21st of November, 2018. Now, Malaj, the normal process is, Malaj, for the governor has the power to keep the assembly under suspended animation without the aid and advice of the Council of Ministers. That power is given under 92 of the Jammu Kashmir Constitution, which he did.
Which
he did, Malaj, on 20th of June 2018. Now, Malaj, the Jammu Kashmir Constitution also says that this will last only for 6 months. That such a decision of the governor will last only for 6 months. That is set out in Article 92, subclause 3. Sorry, Section 92, subclause 3. That such an order will last only for 6 months. Now, which means by 19th of December, there should have been revival of the assembly, because the assembly was not dissolved. See the political motives and the illegality in the whole process. This can't go beyond 6 months, beyond 19th December. So he has to revive the assembly. There's no dissolution. So on 19th December, he dissolves the assembly. On 21st November, he dissolved the assembly. Now, dissolution can't take place without the aid and advice of Council of Ministers. Section 53 of the Jammu Kashmir Constitution. Section 36, 38 and 92 are the only exceptions under the Jammu Kashmir Constitution. I mentioned it earlier also, where the governor can act on his own. But 53 is not. 35, 38 and 92. 30. So, Malaj, he could not have dissolved. And after dissolution, 356 can't be imposed. After Malaj's dissolution, Article 356 cannot be imposed. These are Constitution bench judgments of this court. Now, your lordships asked me the question last time also, you've been asking other council also, why did you not challenge it? Whereas we could not challenge as far as the governor's order of 20th June is concerned, because under the constitution of Jammu Kashmir, you had to put the government back in place within 6 months. Where was the occasion to challenge it? Council of Ministers would have been back in place.
What would happen if there's no conceivable government formation possible?
Whereas he can't do it, that's the point.
This is simple, that's little saying that because it was tenure or 6 months, I can't challenge this wrong.
No, I said I haven't challenged it.
You can't challenge it.
Not, I can't, when I said I can't, I mean, we knew, Malas,
No,
that
you can certainly challenge it, and you do, people do challenge
they
it.
do, but Malas, the government was to come back in place, Malas, was to be put back in.
That may be little.
The government was to be put back in place within 6 months,
But
Malas.
my only question is how, if in 6 months, no government is feasible, possible, then necessity would require a resolution, would it not? What
I'm
would
sorry?
happen? Let us say there is no government possible. Then whom will he put back in? What kind of governors?
So, Malas, what you do is you impose 356, then you dissolve. With the process of under 356, Malas, I've explained it last time also, that you keep the assembly under suspended animation. You see if you can form a government or not, because 356 is a temporary provision to restore democracy. If you find that there is no possibility, after imposing 356, you dissolve and hold elections. That's the process.
So then the dissolution should have taken place under the rubric of Article 356.
That's correct. That's correct. And that's a Constitution Bench judgment. I'll show that to your Lordship straight away. Just keep that judgment. Document volume 19, sorry, case law compilation. PDF 232. This is the Constitution Bench judgment in the matter of special reference 1 of 2000.
Compilation.
Compilation 19, volume 19, Mullah's case law compilation 19. Yeah.
Page?
And the relevant part.
What is the page, Mr. Sibbal?
Mullah's, it starts at 232, PDF 232, relevant is 313. And I've been saying this from day one. This was the political process. The intent was entirely political, and the means were entirely unconstitutional. Oh, sorry.
Draft Assembly?
313 Para 135.
Paragraph?
135.
Volume 19.
Yes, volume 19, case law, volume 19.
ये तो कोई BSNL का judgment. अच्छा अच्छा.
Assembly election matter.
That's correct. Para 135.
So it appears the page 300
318 it says, but the PDF is 313. The running page is 318.
PDF is?
313. Paragraph 135. My lords have it, man?
Yeah.
My Lord Justice Call doesn't seem to have it. You have it. May I read it, Manas? Dissolution brings a legislative body to an end. It essentially terminates the life of such body and is followed by constitution of a new body, Legislative Assembly or House of a People, as the case may be. Prorogation, on the other hand, relates to termination of a session and thus precludes another session, unless it coincides with the end of the legislative term. The basic difference is that prorogation, unlike dissolution, does not affect the legislative body's life, which may continue from session to session until brought to an end by dissolution. Dissolution draws the final curtain upon the House. Once the House is dissolved, it becomes irrevocable. There is no power to recall the order of dissolution and or revive the previous house. Consequently, effect of dissolution is absolute and irrevocable. It has been described by some learned authors that dissolution passes a sponge over the parliamentary slate. The effect of dissolution is in essence termination of the current business of the legislative body. In its sittings and sessions, there is cessation of chain of succession, sittings for a dissolved legislative body, and there cannot be any next session or its first sitting. With the election of the legislative body, a new chapter comes into operation. Till that is done, the sine qua non of responsible government, accountability, is non-existent. Consequently, the time dissolution is non-existent. Stipulation is non-existent. Any other interpretation would render use of the word "its" in relation to the last sitting of one session, the first sitting in the next session without dissolution. Right, Melissa? Now 319. Para 156. Now come to 356. What the court says on 356. PDF page 319. Lord has 156. Justice Gawai.
Yes.
So far as the applicability of 356 is concerned, though in the order of election commission has specifically dealt with the possibility of applying that situation, in the written submissions and the arguments made before this court, the view was given a go-by. And in our view, rightly, mere non-compliance with Article 174, so far as the time period is concerned, does not automatically bring in Article 356. It is made clear that an order of the election commissioner is the foundation and not what is stated subsequently by way of an affidavit or submissions to clarify. But in view of the concession, which according to us is well-founded, we need not go into the question in detail. It is submitted that by some of the learned counsel that the election commission's order otherwise makes out a case of applying 356 when the requirement of 174 is not met. In Thiru Rajagopal versus Karnanidhi, a constitution bench of this court said, Article 356 of the Constitution makes provisions in the case of failure of constitutional machinery in the state, but when the assembly is dissolved, there is no failure of the constitutional machinery within 356. Because the governor was ruling for 6 months, where is the question of 356? So you do it this way, tell the governor, whereas he sort of puts it in suspended animation, less the 6 months almost part when the government, when the two parties say that, look, we are ready to form the government, but that's not proved, Malaj. Then on 19th December, President rule is imposed after the assembly is dissolved on 21st of November. Couldn't be done. If that's bad, and that has to be decided by this court, because that's the basis of 202, 272 and 273. Whether we challenge it or not, that's the very basis. I will. What more do you want me to read?
this can happen, right? Because the section 92 power is sui generis.
Yes.
Normally, even when
He has to act on the aid and advice. No.
normally when an assembly is placed under suspended animation, as we call it, that's also an exercise of the 356 power.
Yes. That's on the recommendation of the governor, Mother.
That's on the recommendation of the governor.
The governor, that it can't be carried on in accordance with the provisions of the constitution. Then 356 is, well, that's what happened.
And the recommendation of the governor again is on aid and advice, or that would not be on aid and advice?
No, it never is.
It will never be on aid.
Never is.
So
No
government
question
will tell
doesn't
the
arise.
president. So we are just wondering, according to you, the dissolution of the assembly on 19th of December is wrong, 19th of November is wrong, because it had to be by
21st November, yeah,
25th of November is wrong.
21st November, yeah.
Because there had to be aid and advice. There was no aid and advice.
Apart from that, Mothers, where was the occasion for 356 at all? Because he was running the administration. Mothers, he's running the administration. There cannot be a constitutional failure. That happens only when the government cannot run in accordance with the provisions of the constitution.
But therefore, no, but we're just testing it like this. Suppose the governor's dissolution is, according to you, incorrect. The consequence would be that at the end of 6 months, the legislative assembly has to be restored.
No.
The suspension would come to an end after 6 months.
Yes. Then the Council of Ministers have to be.
Council of Ministers has to be formed.
Correct.
Now, taking your argument to the logical conclusion that, look, the dissolution was wrong and the governor had to necessarily at the end of 6 months
before
6 months, restore the legislative assembly, lift the suspended animation, invite a government. In which case, can the government of India not have then exercised, the president not have exercised the power under 350?
Correct. So then he would have had to make a recommendation that this is not, they are not functioning in accordance with the provisions of the constitution because the governor was ruling for 6 months. Where is the occasion, Malas, for him to at that time exercise that power?
But if no state government is possible, nobody is agreeing to combine together.
But that's fine, Malas,
in which facts aside.
In which you impose 356. Don't dissolve it. Well, that's the whole problem. You impose 356.
And keep the assembly in suspended animation.
That's always the case. I'll give you several notifications. I don't have the time. That's always the case. What you do is you keep the assembly under suspended animation. You try and, you have to restore democracy. So at some stage you feel that now it's time to hold elections. You dissolve the assembly and announce elections. That's the process followed in every 356 proclamation. You never dissolve the assembly immediately, but then you have to hold elections. The democratic process can't be stultified, can't be used in this fashion. Because this was, as I said, this is a political decision. It has nothing to do with the constitution. I've been saying that from day one, Malas. These are political decisions. Even 272, 273 is political. Maybe I'll.
How much more time now?
Well, not too much, Malas. I want others also to argue, but I've been trying to sort of not even refer to anything and just argue orally, Malas.
Because last day, because
Your Lordship, this is, we are trying to do it as quickly as possible, but Your Lordship is always very kind. Let me not make any suggestion today. Let me, argue tomorrow.
We'll have to wrap up tomorrow. We don't mind extending a little bit for half an hour or so tomorrow. But
I will try and finish as quickly as possible.
So just do make sure that everybody rations.
Yes, that's my whole intent.